Buckle up for justice, buckle up for truth. Fight for every moment, truth and never proof. Feel the fire burning, feel the rising heat. Hearts are always yearning for the righteous beat. Dripped in a jumpsuit, rocking my crown. Lady Justice got style, they can't put her down. Swagger and I strut, skateboard wheels in the head, balancing the scales, freedom street cred. Playing on the blindfold, truth's gotta shine. Crime don't stand a chance, outfit game divine. Walking past the haters, chalk lines fade. Justice is the baddest in the fashion parade. Feels good, midnight, my feet in our hands. We follow every upload, worship what they said. Thumbs up in the millions, comments full of praise. We're the children of the scum, lost in their maze.
Ladies and gentlemen, let's go! Let's go! Mute that stuff. Ladies and gentlemen, we have breaking news to get to right now. Breaking news. The results have come in for the Clayton Echard v. Jane Doe court case heard around the world. June 10th, 2024 was a day where Clayton got to share his truth. And today, June 18th, 2024 will live on in infamy for all of those in Bachelor Nation and beyond who thought they were gaslighted, lied to, their legs were peed on, they were told it was raining. Nay, I say, justice prevailed, and justice is served. We're going to get into an absolute bonkers filing by the judge. We've got our buckle, folks, right here. Loud and clear. Buckle up, folks. This is a wild morning. I actually went for my second round of sleep this morning after the baby was fed by my wife's feeding system known as her boobs. And I burped and we put him back to bed. And now it's time to talk absolute wildness happening out there. We're going to get the file going right now. Should we get into it right now? Let's dive into it right now. We have 600 people in the chat. Listen, Lisa said, did it say he won? Let's don't tickle the balls yet. Let's flirt a little bit. Okay. Let's get into it. Bruce with $20. Bruce, we quite literally couldn't have done this without your emotional and physical support. Bruce was the arms that held up justice while we were being attacked. The mortars were coming in. We were storming the beaches of justice, and Bruce was there providing cover for us. Cynthia, $2. Thank you so much for the super sticker. So we're going to get into all of this right now. I'm going to dive right into it. I know I'm a little late. Like I said, it's been a rough week or two as far as sleep goes, and I didn't get this morning's podcast up till 1:30 in the morning, so I was a little tired, but we got the sleep we need, and we're ready to cover the story. So raise your glasses, shake your butts, and drink some cold brew coffee, for God's sake. It is a great day. It's a great day to be alive. Hold on, I need a coaster. Even though it's a good day, you still need a coaster. Let's use this bill. We need a coaster here because we're sweating. We got condensation. By the way, I bled yesterday. I cut my toe so bad. I got Band-Aids on. I'm pulsating. I might have a stroke happening in my left leg. There's a lot going on. Good to see you. All the best. We are here to get it. It being the truth. So we're going to get into it right now. 800 people in the chat. We're going to get into it right now. Let's dive in. Do you guys want to dive in? Shall we buckle up and dive in? Have you ever had to buckle up while you dove in? That's what we need to do today. Our good pal sent us the gavel here. It says, the Honorable Judge Dave Neal, seeker of truth and justice, barrel scraper extraordinaire. Now, does this mean it's over? Well, we'll have to see what Jane Doe's attorney is already tweeting. It might look like you ever see a kid at the mall who wants to buy some of that stupid kiosk BS stuff, some of the twirling light things, and the mom's like, no, and then the kid has a full-on meltdown. I'm guessing that's what the casita looks like this morning. Kim said, is it bad? I was hoping for a ruling while DG was on vacay. Listen, I could care less if his boat, is clogged up and there's it smells like shit. I don't care what's going on the boat. Maybe some passive aggressive. Maybe they ran out of diet soda and the ice machines are down, so they have to have melted daiquiris. Whatever they need to do. I don't really care. I'm here for justice. He can live his life the way he wants. And that's none of my problem. What he thinks of us is none of our business, but what we think of him is something we'll save for another day. All right, folks, let's get into it. Just Katie said, I have a meeting in 10 minutes. Push the meeting back. It's not important. Why don't we do this? Why don't we go here and I'll enlarge in this. So can I enlarge in this? There it goes right there. All right. In the matters of Jane Doe and Clayton Echard, Jane Doe represented by David Gingras. He puts the gin into Gingras. Don't drink and drive. Versus Clayton Echard and Daddy Zaddy Greg Woodnick, also supported by Deandra, Queen of the Woodnick Law. Judge Mata resides Maricopa County Attorney's Office in Phoenix, Arizona. We were there a week ago. It was hot, baby, but we dripped sweat for that justice. Let me move my camera over a little bit. There we go. Let's get bright and focused here. I got these American flag. I only bring these out on 4th of July, but Independence Day came early. I mean, an independent day indeed. Let's just see some of I'm getting text messages from people. Wake up. The verdict is in Clayton's favor. We got other people. Any word on the ruling? Is it worth it? Let me tell you right now, it's worth it. We also got it in. Greg Gillespie texted us. Oh, no, Greg. Okay, yeah, Greg Gillespie texted us and said, it's a great day to be alive. Under advisement ruling. And by the way, this is going to deliver. So stick around. This is going to deliver. An in-person evidentiary hearing was held on June 10th, 2024, regarding the issues of sanctions, paternity, attorney's fees, and costs. Jurisdictional findings. The court finds at the time this action was commenced, at least one of the parties was domiciled in the state of Arizona, and that said domicile has been maintained for at least 90 days prior to filing the petition. What that means in legal terms is we got someone who lives in a casita with her mom, and then we got somebody who lives on their own in a condo. There are no minor children common to the parties. Well, we've known that for a while. No children indeed. Thank you for the super chat. We'll get to those in a second, but I got to get all my new soundboards. We want to shout out to IT Brad here. IT Goatee gave us this new one.
This will get awkward. This will get awkward.
It will get awkward indeed, but we are here for the truth.
What?
Yes, consequences. Have you heard that word?
What?
You didn't have that in your chat GPT.
What?
But that's okay. We've got it.
Lied.
And we're going to get into it. The court finds that she lied. The court finds fraud. And I'm going to bury the lead right now. The court wants her prosecuted. I'm going to say that one more time, folks. We're going to get to it. I'm burying it. I'm giving you a little bit about what we are about to read.
The blood is on your hands, Dave Neal.
The court wants her prosecuted.
I mean, good God.
Now, look, I don't want any ill will for her. I'd rather her get actual help, but that might not come until she hits rock bottom, and rock bottom might be getting prosecuted. Now, if you're new to this channel, hi, how are you? Good to see you. Just a casual day here. A casual Tuesday. Is it Tuesday already? Is it Tuesday? Oh my gosh. The Tuesday heard around the world, June 18th, 2024. The court wants her prosecuted. Elizabeth said, let's write to the DA. Well, I mean, we'll have to see. Why not? Why not put together a letter to the DA along with the judge making a nice phone call? Hey, attorney's office, you're not going to believe this. What's that? I've never heard of it. Well, just go to Dave Neal's YouTube channel. All right. Procedural history. So let's get into it. Jane Doe petitioner filed a, can we go for names? Laura Owens petitioner filed a pro per petition to establish paternity, legal decision-making, parenting time, and child support on May 20th, 2023. Petitioner Laura Owens filed a pro per means she did it on her own. And boy, is her mom pissed about that. How dare you do this? How dare you commit a con? without my help, or maybe the mom did help. What do we know? Petitioner filed a pro per motion to communicate on August 23rd, a motion to compel on August 19th, an expedited consideration requested motion to communicate filed September 14th, an expedited motion to seal court records on September 14th. All motions were denied. Stupid gavel. Why did we give Dave a gavel? I'm not a judge. I'm the people's judge. Clayton Eckert, respondent, filed a pro per answer on August 21st. The court granted respondent's motion for leave to amend response filed on counsel on December 12th. An amended response to petition to establish filed on January 26th. The parties attended an early resolution conference on September 28th, 2023. The court granted, wherein the parties entered into a Rule 69 agreement to comply with a RavGen DNA test.
I just took a DNA test.
We sure did, and there was no fetal DNA. I jumped to the lead here. On October 6th, petitioner filed for an ex parte order of protection. After a hearing, the OOP was affirmed by Judge Duty, by the way. Let's hear from Judge Duty. What a boomer. No offense to boomers, but that judge gives y'all a bad name. He does. He's like, well, what date was this YouTube video made? I don't know. Check the date on the date. You know what I mean? I have a special Justice cold brew today. Hold on. I need anyone watching this in the casita to hear what victory sounds like. Let's move on. Ooh, it is a little sweet. You're right.
I just took a DNA test.
All right, where were we? Can you guys see this okay? I wanted to keep, it's one of those days where I wanted to keep my face big. I needed a big head for this live stream. 1281 in the chat. Please hit the like button. Check the date on the date. Jerry said, what is this, YouTubes that you speak about? Are you one of those Logan Paul kids that runs around pushing people into water fountains on YouTube? King Bob said, Fox Raid. Oh, is the Fox Raid in? Ladies and gentlemen, Megan, and by the way, Megan, I'm not kidding when I say, we're going to get to this, but I'm not kidding when I say friends for life. I mean, I said this before. Megan Fox and I did both a physical and a metaphysical commencement of friendship, which was cannonballing into her mom's pool. That's not a metaphor for anything greater. We cannonballed into the pool and floated our way to justice. This was after a long and hot Monday where, Bruce will tell you, Bruce, let's be honest. I wish we had a thermometer. I wish we had one. Did it reach 130 degrees on the ground? In the sun, on the ground, you could have cooked a lot of food. You could have cooked more than just eggs. You could have made a lasagna if you wanted to. Either way, is Megan Fox there? If she wants to come in, she can come in. I'm sure she's busy. Let me just say, I'm sure you're busy, but open invite to my stream. I saw a raid from yours, so thought you might be done. The Cannonball Crew. That's what I'm calling her. She's doing an outro now. Okay, so the Cannonball Crew. All right, so let's get into it. We're going to keep on working here. You guys, this has been, when did we start this? September, October, November, December, January, February, March, April, May, June. This has been not nearly a year in the making. I mean, we have been threatened to the moon and back, and still are. We are still threatened. I mean, don't think she's not going to try to file and wiggle something. Could you imagine that the judge basically is about to show that she's guilty, and yet at the same time, she's going to find a way to make this about, I've harassed her and this and that. I don't want to be the main story. I'm just saying here, we know what's coming next. We know we got a Fox. Oh, Megan Fox is in the room, a Fox raid. Megan, I was just saying, you and I, we are the Cannonball Crew. Megan Fox was so kind. I mean, quite honestly, Megan Fox, opened her home to all of us. I stole a scone, and I think I took a fork, actually. Tell your mom I owe her a fork. I'm kidding. I've got a pillow. I've got a Megan Fox pillow. I took a towel. There's a, I hit the mailbox on the way out. We really raided Megan Fox's home. Her parents are so kind. We just went in there and we tore things up. I mean, I put my fingerprints on the windows. We're going to have to clean windows. It was a real mess happening in there, but we were just, look forward to, I look forward to the annual Megan Fox barbecue. I think she'll have us back. Anyway, breadsticks indeed. I tell you what, I gave up carbs yesterday. I had too many people in Scottsdale gave me too many breadsticks that it nearly sent me in a tizzy. But anyhow, Megan Fox needs to write a book. I'm going to be working on the TED Talk that I'll be doing. Yeah, that's right. I'm going to, whether Ted wants to or not, I'm going to call it a Dave Talk. I'm going to do a Dave Talk and I'm going to sell it on Fiverr. And it's going to tell this full story as we sort of digest it. Megan said, I have a gluten intolerance now after all the bread. I mean, Meg, I ate so many breadsticks. I was floating on the top of your pool. You couldn't sink me. I was a soggy, I ate so many breadsticks. My stomach became a garlic knot. How about that? Okay, so anyhow, yeah. So Christy said, why are you making us wait? We're doing a little foreplay. That's all. Okay, we'll get back into it here. Meg, you're always welcome. I'm sure you're busy living life, but you're always welcome. Thanks for kind of alerting me, waking me up. I have a bell system at my house. I have a bell that goes off. Ding dong, the witch is dead. The wicked witch. Ding dong, the wicked witch is dead. Some guys running down the street, Paul Revere style. The judgment is in. Megan wants a link. We'll give you a link, baby. Let's invite Megan right here. I'm going to send it to your Gmail. I'm going to email it to you right here. But anyhow, wild stuff. So it's sent to your, should I send it to your real email or the email you use to harass Gingras? I'm just kidding. Anyhow, you got it, sister. So I'm sure she's not going to want to have to reread this whole thing, but let's get into it. On October 18th, petitioner filed a request for pre-decree mediation, citing respondents' unwillingness to communicate with petitioner, and citing he even asked if the unborn children don't exist, despite a preponderance of the evidence. Well, I mean, define preponderance. If preponderance of evidence means you got a little left on your chin, then maybe, but I don't know. Ladies and gentlemen, queen breadstick of them all, it's Megan Fox. How are you?
I am fantastic, and I just want to sit back and watch you read this and see the glee on my little bro's face.
Oh my gosh, right?
This big win. God, it's so good.
It seems as though Clayton Echard defeated Laura Owens. Is that correct? Do I have the name right?
It would be fantastic. I think that's correct. Yes, that's correct, Dave. I think now, Judge Julie Mata dropped the hammer.
Speaking of hammers being dropped by Clayton, that's what got us into this mess, right? That dick hammer. Okay.
Keep an eye on that hammer, Clayton. Keep an eye on that.
Yeah.
Hammer.
When you only own a hammer, everything looks like a nail. Even throats. Okay. What do we? Okay. No, I don't want to be. I'm class. We have a classy live stream here. I've got my American flag shirt on, my trophy, plastic trophy. I'm going to donate this to Clayton. He wins the trophy. And we're going to get Clayton a proper girlfriend so he doesn't have to deal with this again, and maybe a 24-hour live stream surrounding him, one of those like cameras that belts to you that kind of like sticks out with selfie sticks that always keeps eye on you, just
did you get my message about so there's apparently like a dance competition in Scottsdale. They call it the Dancing with the Stars, and it's like a charity for children. They want Clayton.
Wow. Yeah, I saw that, and I had a wild day yesterday. Between my senior dog and the baby, there was pee and poop everywhere.
Oh no.
And then I went outside to bring the dog in because there's a little tree I let him sit under because he's old, and I just put him out there. And then it got really hot, so I brought him inside. And as I was bringing him inside, I stubbed my toe on my cement walkway.
Ooh.
And I'm not kidding. I'm missing part of my big toe. I stubbed it so bad, I started bleeding everywhere. And I couldn't get the dog inside because I was covered in blood. And then the dog doesn't stand. So I put the dog down, and then he's rolling in the blood. And then the baby's crying. I go, honey, I need help. And she knows that sound. You probably know this, the sound when your partner's actually in duress. It's like, honey, get over here. And she's like, what's going on? I go, bring the Band-Aid kit. And she brings like a little bit. I go, bring the big kit. We need the big kit. So anyhow, I had to elevate my leg. It was a whole day.
Well, did you search for the part of your toe and pack it on ice so they can,
No, you know why? It wasn't a clean cut. It was like I dragged my toe. So it's not, it wasn't a lop off. It was
no.
You ever see how they get the Parmesan at the Olive Garden?
God.
It wasn't.
My husband one time literally cut the tip of his finger off with one of those bandsaw things. And he came running into the house bleeding everywhere. And I had to go look for his finger in the yard. And I found it and I did put it on ice and I gave it. And he wanted to drive himself to the ER, which I just let him do because at the time I had a toddler and a baby. So I was like, yeah, all right, you drive.
I got a really bad cut. We'll get to the thing. Give me 1 minute, folks. I had a really bad cut during the pandemic where you couldn't just go into anywhere. You had to like call ahead. And I had I had a bandage. I had my hand raised and I was typing, do I need stitches? And I was like, well, I think when you Google, do I need stitches? You do need stitches. And I was cleaning a cup just like this. I was cleaning a cup and it broke. Oh, I was like getting the thing in there and it broke and as it broke, I went like that. And I just lost it. Anyhow, so scale of 1 to 10, I already asked you on your channel, but where are we as far as how dramatic, how important, how big this result is?
I think it's huge. I mean, like I said, I'm still in MG Law says it's a 9. I'm saying it's a 12. I had no hope that she was going to be referred for prosecution, and that happened.
I didn't get to that part yet. You buried the lead. No, I'm kidding. Thank you for Sorry,
I screwed the big reveal. But
no, people were saying like, why isn't Dave on your stream? And no, I was asleep. I was. It was really interesting. That was the most calm I've ever felt, and since the baby arrived in my sleep. You know what I mean?
That's good.
Yeah. So it was. Anyhow, I'm just gonna keep reading it. I don't want to bother you, but if you want to be here, be here. But I know you already read it, and if you want to dip in or out, please.
Yeah, I just want to hear you read it.
All right, you tell me what I missed because I'm kind of an idiot with a public school education here. On October 24th, the parties appeared before Commissioner Gil Ketsis in CV 2023 in response to the injunction against harassment filed by respondent. On the party's stipulation, the court previously reviewed both days of the hearing and identified that the petitioner, appearing virtually, frequently stood up and rubbed what appeared to be a swollen abdomen. That's what I did after the scones. I had a swollen abdomen. All because Clayton had a swollen,
hammer.
Hammer. Clayton's hammer. That's what we're going to call him now.
Clayton's hammer.
That's the new TED Talk. Clayton's hammer. Brought to you by David Nail. November 2nd, testimony resumed, and petitioner testified that she was 100% and 24 weeks pregnant with respondent's children. She further testified that the twins were due on February 14th, 2024. She further testified that due to epilepsy, she was experiencing high-risk pregnancy and was being cared for by 2 specialists, namely Dr. McCool and Dr. Higley. She testified she last saw Dr. Higley last Friday prior to the November 2nd hearing. So even if I don't know what's coming next, at this point, we see all of the setups happening. All of the fraud is being laid out right now about what she's testified. October 25th, the parties appeared before Commissioner Duty to determine the validity of the contested OOP. Petitioner's abdomen again appeared swollen she had an engorged abdomen, folks. During this hearing, she testified to the validity of the sonogram sent to respondent, the media, me, Steve, you, and a Dropbox on Reddit, and further testified the parties were having a son. She later testified she believed she was having fraternal twins, 1 boy and 1 girl. Now, Meg, what's your date? What's the date of the first day you heard about this? Was it 2023? Was it late December?
It was 2024. It was January. It was, I believe our first meeting, you and me, was January 6th. So, or January 6th was the first day I did a stream, and then we met the next day. So I probably heard about it right around the 1st or 2nd. And it was my listeners started like tweeting me going, you've got to see this. Some of your, I think some of your people were like reaching out to me, or maybe we shared a couple of audience members because they were like, you got to hear this story. And they sent me to your videos. And I was just, a lot of the times, if I get more than 1 or 2 people saying you have to look at this, then I will definitely look at it. And that's what happened. As soon as I saw your first video, I was like, oh my God, this is insane.
I just got a text message from my lawyer congratulating us. So I want to thank him for all of the kind work. I got to tell you, a good lawyer, when you think you got no, I mean, because I had to get my lawyer, I don't know, back in maybe October, and a good lawyer when you think that, you're in deep trouble is just amazing. Give me a second, folks. I'm trying to pull up my Instagram, but I'm having an issue here. We do have an update from Clayton. So I'm going to share what Clayton.
Oh, that's
did you see
great.
Clayton's update?
Did your lawyer did you send this to your lawyer, or did he get it somehow?
No, I think he's watching right now. I don't want to say his name. I don't want any harassment going. Not that it would, but he just said you totally have a TEDx talk out of this, or no, he said TED Talk. Look, I don't think TED Talk would come near this at all, but regardless of if they come near it, I'm doing it. By the way, yesterday we actually I screen grabbed the background from her TED Talk, so I'm going to change this to DAVX. And then under here, I might put Clayton. I don't know what I'm going to put under here. Maybe Justice. And then I should
say Daver X.
So she's going to walk in and do her thing. And then it's going to go pause. And then I'm going to walk in and go, hey. And then I'm just going to go, hold on 1 second. Actually, it turns out everything you're about to see is not true. And I'm going to pause them on every step of the way. So that'll be the next thing we kind of work on. I'm having a hard time pulling up Clayton. I think every once in a while.
Let me see if I can do it.
Once in a while, Instagram completely shits the bed on desktop. That girl said, I need Dave on Caitlin's podcast again. I'm sure she's dying for more tea. Actually, I think she's releasing my podcast episode this week. I went on her show this past Wednesday, so I didn't get the update for her. Yeah, I mean.
All right, I can pull it up. So where is it? On Reels?
I think it's a story.
Story.
He might not be addressing it by.
Oh, I don't know how to navigate Instagram. You gotta here. Let me. I'll share it with you so you can see it, and maybe you can tell me where to go because I don't see anything new. All right, pull it up on the screen and then tell me where to go.
Okay, so click on his face. Oh, you are such a.
I don't know how to use Instagram.
All right, so what does it say?
Best day
pause it up
ever.
Top.
Oh, pause.
Okay. It says best day ever. There it is, folks. Clayton receiving all the love online. So very fun stuff. So I'm sure he'll have a proper post. And when he does, we'll get to it. All right.
That's awesome.
I have an unruly audience that wants us to get back to the file. So here we go. If anything else comes in statement wise, we'll just get into it. Okay, so here we have, we continue. December 6, 2023, a second RavGen test confirmed little to no fetal DNA.
I just took a DNA test.
A third test was done. However, the test results were lost in transit.
What?
December 12th, respondent filed a notion of filing affidavit of non-paternity. So at this point, this is when he actually goes on the offensive and says, no, enough is enough. This is the point that she writes the cyberbullying article against me. I'm sure Clayton felt bad for me, but the truth is he knew he was next. He knew if she was going to write an article about me, that his story needed to be told, in an offensive way, not on the defensive. And boy, she does not look pretty metaphorically when she's on the defensive. She's all spit and fire when her lawyers are up there. But when Clayton asks her one simple question,
what?
December 28th, petitioner filed a motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support with prejudice in conjunction with the notice requiring strict compliance with Arizona rules of evidence. Petitioner cited the basis for the dismissal that she is not now pregnant with respondent's children. The motion was denied as the issue of attorney's fees, costs, and sanctions remained.
This will get awkward.
January 2nd, petitioner filed an expedited motion to quash deposition of petitioner. January 3rd, respondent filed a response objection to petitioner's motion to dismiss. The court denied petitioner's motion to quash. Respondent withdrew his motion for sanctions. Petitioner filed a motion for confidentiality and preliminary protective order on January 18th. Respondent participated in a deposition on February 2nd. At a status conference on February 21st, petitioner was ordered by the court to comply with Rule 49 disclosure requirements. During the hearing, petitioner's counsel advised that the petitioner had miscarried sometime in September. I think that was Corey Keith, right? 2,000 people in the chat. Thank you guys so much. We'll get to super chats in a minute. Petitioner was deposed on March 1st. Again, They left this part out, but she was deposed several days after saying she was going to sue him for $1.4 quadrillion, I think, $1.4 million, which we consider that to be extortion. Her attorney says, "What? Come on, we're partying. Swollen. We got swollen bellies. What are you going to do?" She would have sued him, but her belly was swollen. On June 3rd, I think her decision-making part of her brain is swollen. On June 3rd, petitioner's prior counsel filed Ethical Rule 3.3 Notice of Candor, wherein counsel advises the court that statements made by counsel at the February 21st status conference were factually incorrect. Specifically, counsel stated, Ms. Owens has not lied in this case. She has not lied in this case. She has not intentionally lied to the court. Oh, that was what he initially said.
That was what he said that he had to correct.
And he said, oopsie. While counsel...
He found out that wasn't true.
Oh, justice for Corey Keith, please. While counsel believed the statements to be accurate at the time, counsel later determined those statements were not true based on the petitioner's deposition taken March 1st, 2024. Voluminous additional pre-trial pleadings were filed by both parties. Those motions were ruled on separately by minute entry, and the rulings are not relevant for purposes of this hearing. Findings of facts. Oh, you guys want the facts? You want the truth? You want the facts? Can we handle it? I got one of those buttons somewhere. Maybe I don't. I don't know. I had the button here. There it is.
You can't handle the truth.
Well, we think we can. Maybe Jane Doe can't. Petitioner Laura Owens. Petitioner, and this is what Judge Mata. So have you ever read one of these before? Because it's obviously different than sort of a bigger court case here. This is the judge's interpretation of everything that happened. Is that correct?
Yes. So during the court case, if you noticed, a lot of people were like, how come she didn't notice that he was, waving his arms and stuff? It was because the judge was taking notes. She was taking detailed notes. And if I were to guess, these were the notes she was taking. She was on her laptop and she was typing away furiously. So that's
that. I thought she was in our chat room. I thought she was just in the YouTube chat. I mean, hey, we've got people skipping yoga for this, says Miss Daniel. By the way, you can do yoga while you watch this. Please contort yourself into Warrior 3. This is a good Warrior 3. Just hold tree pose while we do this. Now, because you guys are eager beavers, you're going to try to read ahead. I'm going to go one line at a time right here. Petitioner Laura Owens. Petitioner contacted respondent through LinkedIn. Fact. Petitioner and respondent met on May 17th to locate potential investment properties in Scottsdale. Petitioner has a podcast, a real estate investment company, and buys and sells horses. Between May 18th and May 20th, parties viewed some properties in Scottsdale. On the evening of May 20th, respondent, hold on. I am not button ready for this.
This will get awkward.
Between May 18th to May 20th, on the evening of May 20th, respondent invited petitioner over to his home, which she accepted. After petitioner arrived, respondent told her he was high on cannabis gummies, and he offered one to her, which she accepted. During the late evening of May 20th, in early morning of May 21st, Clayton, you dirty dog, both parties agreed that petitioner performed oral sex on respondent to completion twice. Because Clayton's not a quitter. Petitioner testified she did not want to have sexual intercourse, but that respondent stuck it in briefly. Petitioner's implication that respondent initiated sexual intercourse without consent was not alleged initially in the court filings. It was not alleged until 2024. Que convenient, as the French would say. How convenient that she waited to allege that. At trial, petitioner testified that the parties had sexual intercourse and that it was the R word. Petitioner testified respondent was too high to remember sexual intercourse due to his voluntary intoxication. Petitioner believes she became pregnant on May 20th, 2023. She testified that after May 20th, 2023, her menstrual period stopped and did not resume until November 2023. Petitioner has had PCOS since the age of 17 and does not have regular periods. Petitioner has a history of epilepsy. Petitioner testified she has been pregnant 4 times. And by the way, I actually think it's 5 because Clayton, Mike Maricini's actually twice, Greg Gillespie, and then Matt. So I think it's at least 5 times she's claimed pregnancy. Each time the alleged father believes she fabricated the pregnancy and doctored medical records. I wish I was included in this. Dave Neal layeth down the hammer on Jane Doe. He hit her on the top of the head with the truth, metaphorically. On May 24th, petitioner asked respondent to prepare written purchase offers for 2 properties petitioner wanted to purchase in Scottsdale. One was located there, and the other was located there in Scottsdale. One for $425 and one for $700. Petitioner asked respondent as her realtor to prepare these purchase offers and to submit them to the seller or the seller's agent. Respondent prepared the purchase offers, which petitioner signed on or around May 24th, but respondent never submitted them to the seller or the seller's agent. Petitioner later asked respondent if he had heard anything from the seller in response to Laura's offers. Respondent advised he had not heard back from the seller. Petitioner testified that she advised the real estate board and action was taken. On May 31st, petitioner took a home pregnancy test, which showed a faint positive result. I like that she called it faint, because in anywhere did they describe the hardness of the line? I don't think it was ever talked about. So for her to call it faint was interesting. But
I think it was during the deposition. I'm pretty sure during her deposition, that's how she described it. It was a faint line.
Very, very nice here. And she's going to have she's going to faint when she reads this. Or not. Maybe she's just that delusional. Who knows? Petitioner testified that after multiple positive pregnancy tests, she told the respondent she was pregnant. Petitioner denies using hormones, someone else's urine, or altering the test at all. Petitioner found, if petitioner denied it, that must be true. So we should just, petitioner found respondent's reaction to be hostile and dismissive. On June 1st, petitioner went to Banner Urgent Care on Greenway and 64. She informed the nurse that she believed she may be pregnant. She asked for a test to determine whether she was, in fact, pregnant. The test result from Banner Urgent Care was positive for pregnancy. Petitioner testified that for more than 6 months prior to May 2023, she was not sexually active with any other men. Based on this, petitioner testified that she believed she was pregnant and respondent was the only potential father. All right, get to it. June 19th, petitioner went to respondent's home at his request. Petitioners provided a pregnancy test for petitioner to take. Conflicting testimony made it difficult to ascertain whether the test was taken in front of the respondent or with the bathroom door closed due to a shy bladder. Oh my gosh. How's that for a new song? Shy bladder.
Shy bladder.
I've never understood that. I've been able to pee anywhere I want. But hey, what do I know? And I don't want to shame shy bladders. They exist. Both parties agree the test was positive. You know, because in urinals, you got to pee right next to people. And if there's 5 urinals, usually a guy pees all the way to the one side and all the way to the other, which I always thought was very homophobic. If there's a guy peeing and there's an open set of urinals, I like to pee right next to that guy. I like to let him know I'm there next to my brotherhood. Peeing, streaming in conjoinment with each other. I like no shyness. I've got an extroverted bladder, to be quite honest. My bladder is the lead of the show. Okay. We'll continue. I'm literally killing people right now. A respondent provided a pregnancy test for petitioner to take. Shy bladder. Both parties agree the test was positive. In the something to consider email, the court finds the language to imply respondent was attempting to buy into the idea that rubbing or grinding their genitals together might have led to a pregnancy.
This will get awkward.
The court, however, does not find the email conclusive that respondent believed her to be pregnant with his children, but rather an attempt to consider her ascertains. Oh, this is so smart. In the something to consider email, respondent maintains that the lack of sexual intercourse would preclude him from being the father of the fetuses. The email does not deny the pregnancy test was positive. In the email, respondent suggested that the positive test was a result of petitioner's epilepsy medication. Petitioner emailed Dr. Zeman, MD, from Barrow Concussion and Brain Injury Center on June 28th. The subject of the email is pregnancy and seizure med, ? Do we see this one? I don't even remember this.
Yeah, I don't remember Dr. Zeman either. And it came up in trial, and that was one of the records that I don't remember ever seeing. I don't remember ever seeing this. This might be one of the ones that was sealed away from the public that never came out in a exhibit.
All right. Yeah, a lot of talk in the comment section about not crossing streams. Someone said they get a shy bowel, which makes vacation hell. I'll tell you what, I almost shit my pants in a canoe. I'm not kidding. The same day that I got a cease and desist while I was in the Maldives, My wife, we couldn't have separate kayaks because she was kind of not high risk, but she had something going on in her early pregnancy. So they told her no physical activity. So I'm paddling, and I'm telling you right now, I don't want to make this gross, but I had to book it to the sideline and run into I couldn't even use the hotel bathroom. I had to run into the restaurant bathroom. But either way, I digress. It doesn't matter.
All right, I'm going to pop off. If I can come back later, I will. But I thank you for doing this, Dave.
Wow, we walked Megan Fox with that.
Congratulations. Don't worry. It wasn't that. It's just that my family who's visiting just came back from their shopping trip. So
tell them I said hi and tell them I'll return the pillow.
Okay.
But thanks again. We'll talk later, but thank you for all
right,
all
guys. Enjoy.
All right, Megan Fox, everybody, go give her a follow on YouTube. Keep on supporting with your dollar, with your follow. We appreciate you guys so much. Petitioner denies sending respondent an ultrasound video, citing instead that Greg Gillespie hacked into her email and sent the video to respondent. Petitioner testified that July 2nd, she anonymously sought care at a Planned Parenthood in Los Angeles. While she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias, respondent presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up until today, petitioner disclosed she sought care. Petitioner testified that she had the sonogram at a Planned Parenthood in California, either anonymously or under a pseudonym, and changed the location to prevent respondent from tracking down the records. The court was not provided with those records at trial. Oh, why not? Because I was anonymous. This judge ain't buying shit, folks. This judge ain't buying it. And neither did we, and that's why we're here. But unbelievable to see. Okay, look, guys, we're already up to 20 super chats. I got to barrel through them. Lindy, $20. Thank you so much. Congratulations, Injustice wins. I appreciate you. Taz, $2. Congratulations to Clayton. Congratulations indeed to Clayton. WK with $20. Thank you so much for the support, guys. Then we've got LFNC. She lied. I didn't have my button ready. There it is.
She lied.
$20. Thank you so much for that. Stephanie, unbelievable. Whenever I get this magenta color, you know it's good. $50. This is by far my favorite find out in the world of effing around. Great work keeping this in everyone's face, Dave. I mean, look, we lost some people, but we gained a whole new group, so we'll take it. Thank you so much for sticking around. Julie, is this Judge Julie? No, Judge Julie Ann Morel, $2. Judge Mata or Queen Deandra for driving with Dave. Oh, I would love that. I would absolutely love to have. We could do a whole carpool episode. Get Isabel in there. Sherry, $10 super sticker. Lady K, Texas. Thank you so much. $20. She lied. Congratulations, Dave.
She lied.
It's a good day indeed. Thank you. Thank you. Thank you. Cynic and Chief, $10. Breadstick, pasta e fagioli, and salad with Italian dressing. Money. I think I'm gonna go get Italian today. I got a what's it called? Olive Garden in my neighborhood. Lisa B, $10. Thank you for your perseverance, Dave. Laura and Dingus can suck it. Well, that's what got us into this mess. Come on, folks. Let me just make sure I delete these old ones. La Jourdain, $5. Gingras is talking smack about the judge now, too. We'll get into that. Hang tight for that. Tracy, $10 says, congratulations. It was a con. We were just on the right side of it. We sniffed it out. The Curious One, $5. Dave, can your next series after this is over be what's on the docket today? Justice looks great on your channel. Well, thank you so much. I'm wearing Justice very well. We will absolutely, listen, trust me, with this court case, we're still going to have a lot to cover. Lauren, $5. Congrats. I hope she leaves you alone. I've enjoyed following this story with you. I'm going to get into that in a second. I'm going to get into her leaving me alone in a second. Wendy, $5. Hi, Dave. This is such great news for Clayton. Thanks to you and all the others. Bless you all. Thank you so much. Let's see here. Robin, $2 celebrating justice for Clayton. Thank you. Lady K, Texas, $5. What you want to bet? She is texting Dingus nonstop right now, I'm sure. And then we have a 50R. I don't know. Is that Russian? What's 50R? All the best, Gingras. Thank you. I don't know what the R means. Let me know what the R means, but I appreciate the 50 currency right there. Two more. Susan Brown, $10. Yay for justice. She'd look great in either orange or stripes, right? I would like to see her in a facility that gets her back on track. As I've said, and I'll say it again, we will push, as long as she wants to talk truth, if she wants to tell the truth, we will push her story and elevate her platform And I quite honestly, I'm not saying that as a reward for all of this. Her credibility shot. But if she wants to come forward and tell her story and really break down and none of this stupid,
what?
And really tell a story, I will be here to say, hey, I'll be the first one to send her a $5 breadstick money. So proud of everyone says a long way to Tipperary. Thank you so much. And Mary, $2. Thank you, Dave, for helping Clayton through all of this. Yeah, I mean, look, we've developed an odd brotherhood, both our community and also Clayton, Mike, and Greg. And now we've got Clayton, Mike, and Greg still have restraining orders against them. So we're going to get into that. Let's keep going. Kimmy says, yeah, hope this paves the way for Greg and Mike and any other victims of hers. Well, there's still work to be done. And if this gets, by the way, guys, if the prosecutors pick this up, we've got so much evidence for them that didn't make it into this court. You guys donated money that verified that expert, verified the laptop. That laptop still exists. That laptop didn't burn up. Mike, my message to you, put that laptop in a climate-controlled safe. Save that laptop. Should we donate to Mike to save that laptop? Don't you dare do anything with that laptop. Well, I'd like to buy it for... No. Whatever anyone wants to buy it from you, don't do it. Save it. He's got backups on his hard drive, but isn't it nice to just open a laptop and just see the truth smack you right in the face? All right. Anyhow, let me just take a quick sip here. 2,500 people in the chat. By the way, it gets better. Petitioner testified. Okay, we got the Planned Parenthood. Petitioner testified that on July 23rd, she experienced bleeding and passed two small fleshy objects smaller in size than her hand. She took pictures of the tissue and sought telehealth assistance. Petitioner testified that she texted a miscarriage hotline and sought telehealth assistance. The telehealth provider told petitioner it was hard to tell if she miscarried and she should monitor the situation and seek further care as needed. Petitioner chose not to seek in-person care that would have confirmed if she had been, still was, or had miscarried. The court finds the hard-to-tell component of the telehealth visit was due to the nature of telehealth and the inability to provide care in the form of an exam, HCG test, blood test, ultrasound, or sonogram. Instead of seeking in-person care, petitioner chose to take another HCG home pregnancy test on July 25th, which was positive. By the way, at this point, you're thinking that all the cards are being set up to really punish her. That's what you're thinking. Petitioner again took an in-home test instead of seeking care on August 1st. Petitioner testified that she made multiple appointments to see Dr. McCool. 3 of the 4 appointments were rescheduled and then canceled when the petitioner tested positive for COVID. Dr. McCool's records indicate 44 pages of records confirming, making, and canceling appointments. The court was not provided with evidence of the positive COVID test, but maintains that the nature of her high-risk pregnancy would warrant a visit to the emergency room, who would be equipped to care for a high-risk pregnancy wherein the mother was COVID positive. Steve said her ruling will... No, I got it. Want to join my live stream while I read it? I'm going to email Steve right now, the live stream here, and just in case he wants to join. And Steve, Reality Steve, the Steve Carbone just sent if you want to partake. It's wild. Reading now. We're going to get Steve on the line here. Oh, Carbone. The Carbone himself is going to come in. Hopefully, maybe. I don't know. Maybe he's having his, Olive Garden breakfast there. All right. We're getting there, folks. We're getting there. Hang on. In August 2023, the parties agreed to a DNA test through Ravgen.
I just took a DNA test.
Petitioner paid $725 to Ravgen for the test, but respondent failed to provide a sample, and petitioner canceled the test on August 18th. Now, Clayton says that he, wanted to take a test, but she had all these stipulations, and that's why he needed to do it, or that's why he didn't do it. The court does not find the sexual contact between petitioner and respondent resulted in a pregnancy. The court does not find. Oh, we're just jumping all the good stuff. The court does not find the sexual contact between Laura and Clayton resulted in a pregnancy. Whoa. That's a big court finding. That is a big court finding. Angela said, I'm thinking Gingrich left the country knowing the outcome of the case. Doesn't matter the outcome. He was still paid. Well, yeah, I mean, I'm sure he knew. I'm sure he's no idiot and knew he was fighting a tough fight. But you know what? Did Gingras take advantage of Laura? It's a good question. You guys let me know. I don't know if he took advantage of her. I mean, everyone's entitled to a defense, but man, I don't think you're entitled to lie for your client. You know what I mean? Twisted Life said Clayton's name is now cleared. That girl said he probably left with Laura. She's planning on fathering him up. I don't know if that's the case. I don't think he went with Laura. Although, who knows? You know what I mean? Maybe they developed a bond. The court does not find the sexual contact between petitioner and respondent resulted in a pregnancy. The court finds that if the petitioner was pregnant, it is profoundly unlikely that conception occurred because of rubbing, grinding, or oral sex. During this litigation, if petitioner had maintained consistently an allegation of SA coupled with a police report or physical exam, the court may find differently. Evidence and testimony, however, do not support this inconsistent contention. Oh, how interesting. How very interesting. So, hey, that's the judge basically saying, look, come on. I hate to say it, but like you didn't have the police reports, the physical examinations. You had none of the information that would have benefited you. And of course, she could have gotten that in September or October when everyone was saying, hey, prove it. We were saying, look, just prove it and we'll shut up. I mean, how easy is it? You could have hired an ultrasound technician to come to you. Yeah, rubbing, grinding, or oral sex. Doesn't that sound like a Boys to Men song or something? I'll make love to you if we grind or... Okay. If you hold me tight. Oral sex all through the night. I'll make love to you. All right, let's go. During this litigation, if petitioner had maintained consistently... Okay, we already got that. Evidence and testimony, however, do not support this inconsistent contention. Petitioner admitted to changing an HCG test result to reflect 31,000. That's wrong. It was 131,000. She further... That's an error right there. She admitted to changing an ACG test to a 131,000. She further testified she altered the document using Adobe, but not Adobe Acrobat. Really? She said she didn't use Adobe Acrobat? I thought she did. In late September or early October, both parties submitted samples to Ravgen for DNA testing.
I just took a DNA
October 16th, the petitioner's blood was drawn and the results were HCG levels of 102.00. Petitioner changed the result to reflect 102,000. Again, also, I believe that's a discrepancy that was caused by her attorney saying 102,000. It was 131,000. It doesn't matter. That number is kind of irrelevant. The fact that she changed it to a bogus number, but petitioner and I hope this isn't something that is like able to be looked at through an appeal, right? I mean, irrelevant. Petitioner, but we do know her attorney tried to smear Deandra by saying she was like dishonest by saying 102,000. Clearly, there was 102,000 was a number floating around. Level 102,000 needy indeed. Petitioner testified that on October 18th, she was aware the alleged pregnancies were not viable. Hold on, I gotta tell her to bring him in here. 1 second, guys. I have to watch the baby, but we'll continue to stream here. Rubbing and grinding all the twins we are finding. Having the babies if I don't hear back. Date with intent. I'll be a tight snack. Yikes, Bruce. Oh my gosh. You might be an R&B lyricist. We might have a new profession on the hands here for Bruce. Bruce the Moose. DJ Bruce the Moose. Hold on 1 second. Hey, honey. All right, just making sure. I'm supposed to watch the baby right now, but he's doing okay. He's boob drunk. You know that? You know when a baby drinks breast milk, his arms go limp and he's like, oh, he's boob drunk. It's a good flow this morning. He might have drank a little extra because he was so happy with the news. You know how babies are. Yeah, just took a DNA test. All right, let's continue. 2,500 in the chat. Thank you guys all so much for those super chats. Much appreciated. Petitioner testified that on October 18th, she was aware the alleged pregnancies were not viable and filed the request for pre-decree mediation in the hopes that at mediation, she could tell the respondent that the pregnancy was no longer viable. Upon denial of her request, however, she did not file a motion to dismiss or make other arrangements to advise respondent of the development. The court finds this testimony uncredible and a misuse of judicial resources. Yikes. Petitioner was not treated by Dr. McCool or Dr. Igley as testified to in her November 2nd, 2023 hearing on the IAH. Donnelly, thank you so much. I really appreciate it. Says Dave, your integrity, decency, and kindness has been a beacon in all of this mess. This is such a huge victory for both of you. I don't know how I'm going to. I mean, I almost got teary-eyed reading that. Maybe. Whew. Let's just go. Whew, whew. Maybe it's the cold brew, guys. Oh, wow. My love language is affirmations, and you just. Yeah, I wasn't ready for that. Thank you. Excuse me. Where the hell were we? You just blindsided me. Upon denial. Jeez. Where are we? The court finds this testimony uncredible. It was incredible and uncredible. But either way, it was not credible in a misuse of judicial resources. Oh, I was just the justice is flowing out of my eyes. Can you feel the justice flowing out of my, oh my gosh, that's glassy. I have glassy eyes right now. That's justice. Again, not to make a big deal. Whew. Why is it every time I go this way, it makes it more emotional? I'm not trying to make a big deal out of it, but I'm, Steve's going to come on. When I think of this case, personally, it's more than exonerating these men because of all of the threats that have come at me and the sort of attempts that you just don't know. And so I've said before, I've got the vaccine of what it's like to be smeared here, because I got a little bit of the attempts at mischaracterizations and the attempts of smearing, and I've got a little bit of that, just a little bit. But I had the knowledge. I never met her before, so I knew, so people could believe that I wasn't guilty of these things, but it still sucked. Clayton, Mike, Matt, and Greg, they got the full force of the mischaracterizations. So I can't ever put myself in their shoes, but I see their shoes and I go, oh my gosh, this is like, might not be the biggest deal in the world to others, but to them, this is the biggest deal. And Clayton, he deserves every victory dance he wants. I want him on Dancing with the Stars. God damn it. I want him on Dancing with the Stars. And my guess is once this becomes a documentary and becomes mainstream, I'm calling it right now. On June 18th of 2024, I'm calling it right now. After the documentary goes viral and people realized he was absolutely damned and absolutely just hammered throughout all of this, we're going to see Clayton Echard on Dancing with the Stars. And boy, he's going to do good. He's going to do good. And his time will come. We're going to ride that pony to victory. We're going to do it. Anyway, thank you guys so much. Let's continue. Upon denial of her request, she did not file a motion to dismiss. Petitioner's alleged pregnancy was not treated by Dr. McCool, Dr. Higley, or any other in-person obstetrician or gynecologist. The court finds failure to seek in-person care for a high-risk pregnancy to be both unreasonable and uncreditable. The court further finds that going to Banner for a pregnancy test, but not the passage of fetal tissue, to be unreasonable and uncredible. The reasonable person, if seeking emergency room care to confirm a pregnancy, would not rely on telehealth to confirm the non-viability of the pregnancy.
What?
And her response is, but I texted that, I just wish she could read this and go, yeah, you got me. Oh, you got me there. Yeah, you got me there. You know what I mean? But it's like, don't fight it, honey. Just go with the flow here. Take the loss. I've lost so many things in my life. So many sports matches. I've bombed on stage. Take the loss. I've been rejected a bunch, Hey, how are you? Where are you from? Her friend's like, Oh, okay. You want me to go F myself? Bye. Learn how to take rejection. It's a beautiful thing when you learn rejection. Rejection is just being diverted into a new direction here. That's all it is. Bruce said she'll never admit it. I don't know, Bruce. I don't know. Maybe she has mushrooms and goes to a Joshua Tree, has a giant Sonic milkshake, something that really rattles the brain. You never know. The court further finds, petitioner testified that on November 14th, she sought OBGYN services from a facility, Mom Doc, to determine whether she was allegedly still pregnant. At that point, petitioner took 2 pregnancy tests that were both negative. Petitioner testified that she currently weighs 91 pounds, but weighed 133 in November during her Mom Doc appointment. She experienced significant swelling in her abdomen and felt pregnant. The court was presented with videos dating September 19th and October 9th. Petitioner sent respondent of her abdomen as evidence of pregnancy. Dr. Medchill testified that while she appeared pregnant, that alone was not conclusive of pregnancy. Petitioner denies tampering with HCG tests, but does admit to altering and fabricating ultrasounds and sonograms. She further testified that she changed the HCG numbers on 2 of the results. To me, again, I think she would have lost this already, but boy, I just have to remind Laura Owens, David Gingras lit a fire under my ass. We would not have found one of the ultrasounds, the one that was your sister's. We would not have found the HCG test, and we would have not have found the Fiverr logo if your attorney wasn't point blank an asshole. He went in there to ruffle feathers. He just ruffled the wrong feather. He ruffled my feathers. And you know what? We doubled down and we found the truth. And a guardian angel led me to my inbox and I said, guardian angel, how come there's only one set of footprints walking to the inbox? Have you abandoned me? Have you abandoned me? As I walked into my inbox, and guardian angel said, sweet child, there's only one set of footprints because I carried you to your inbox. And I said, well, thank you so much, guardian angel. And then I gave my guardian angel a super chat. And that's the story of finding the evidence. I know I'm congested here. I'm emotional. The court was presented with videos dated. Okay, we got that. Petitioner denies tampering. Okay, the court finds little, if any, difference in altering the test itself, for which she denies, and altering the results, which she did tamper with by her own admission. During petitioner's cross-examination by lovely Deandra, Sharon said, Dave Neal, you are Clayton's angel. Well, sure. Thank you. Footprints. Maybe I'm going to get that footprints printed out. What is it? A footprints saying. Maybe I'll get that printed out and I'll have it adjusted to have all of the info. You know what I mean? Here it is right here. Remember this one? The footprints. One night I dreamed I was walking along the beach with Clayton Eckerd. Scenes from my life flashed across the sky. In each, I noticed footprints in the sand. Sometimes there were 2 sets of footprints. Other times there was only one. During the lowest times of the trial, I could see only one set of footprints. So I said, Clayton, you promised me that you would walk with me along. Always. Why, when I needed you the most, would you leave me? Clayton replied, my precious power recapper and journalist. I love you and would never leave you. The times when you have seen only one set of footprints, that's when I carried you like a sweet baby to victory. Okay. I hope I didn't offend any Christians there with my retelling of the footprints. It's a lovely story. Let's continue. Now's not the time. Petitioner denies tampering. Okay. During petitioner's cross-examination by the lovely Queen Deandra, it became profoundly obvious that counsel for the petitioner was attempting to coach her answers. Oh, we got the coaching coming in. Oh, Coach Gingras. And by the way, apparently someone said, we have a couple songs that people want me to play. I'll play the songs in a minute. Let me play the songs in a minute while I clear my throat. Let me clear my throat. Let me clear my throat. Kim Duncan says, we don't want Jane Doe and Joshua Tree. Oh, no. You've sent her a cease and desist from arriving in Joshua Tree. All right. We have 2,669 people in the chat. So we've got a good one happening. During petitioner's cross-examination, it became profoundly obvious that counsel for the petitioner was attempting to coach her answers. Can we call Gingras Coach G from now on? Let's call him Coach G. Coach G, come on. He looked like he wasn't coaching her. He was trying to land a plane. Look, Carlton Fisk. You know the reference. The Red Sox kid. Profoundly obvious, said Jen. Profoundly obvious indeed. CB said, thanking you for never backing down, Dave. Respondents counsel identifying the issue moved between counsel and the petitioner. Yeah, Deandra played defense there. From that point forward, the petitioner began to exhibit extreme anxiety and unwillingness to answer questions. Yes, that's right. She was rattled. And as we covered this, Tilted Lawyer said the same thing, that, boy, she was so rattled. And that's when she lost. If she hadn't already. I just took a DNA test. So hold on a second. So Reality Steve's about to join us. Guys, we're getting to it. I know you want it all right now, but like good lovemaking, we're just going to take some time here. And I'm just going to play a song for you while I'm going to reset. My short shorts have bunched up, so I'm just going to reset. This was sent to me. It's called Preponderance of Evidence. This was just sent to us. Let me know if you can hear this. Reality Steve's on the way. My shorts are bunched up.
She walks into the courtroom dressed in black. Laura O with her demons on the attack. Fake pregnancy
you hear this?
schemes. She's done this before. 3 men down, baby number 4. Preponderance of the evidence. 51% is all we need. Arizona justice, it's a wild, wild scene. 2 hours to argue, but the truth will shine. Thank God for the preponderance, the scales align. Her lawyer's got a name, they call him Gingras. Douche canoe, tramp stamp, he's the demon's mask. Deceptive smiles, twisted lies, they deploy. But the truth's a beacon shining through their ploys. Preponderance of the evidence. 51% is all we need. Arizona justice, it's a wild, wild scene. 2 hours to argue, but the truth will shine. Thank God for the preponderance, the scales align. Her lawyer's got a name, they call him Gingras. Douche canoe, tramp stamp, he's the demon's mask. Deceptive smiles, twisted lies, they deploy. But the truth's a beacon shining through their ploys. Preponderance of the evidence. 51% is all we need. Arizona justice, it's a wild, wild scene. 2 hours to argue, but the truth will shine. Thank God for the preponderance, the scales align. Beyond a reasonable doubt, they thought they need more. But the evidence is heavy, and justice will score.
Be right back.
No need for shadows, no tricks to employ. The truth will conquer, lies will be destroyed. Preponderance of the evidence. 51% is all we need. Arizona justice, it's a wild, wild scene. 2 hours to argue, but the truth will shine. Thank God for the preponderance, the scales align. Laura O and her lawyer, their game is at its end. Justice in Arizona, no more lies to defend. The truth has won, the evidence is clear. Preponderance of the evidence, the verdict is here.
All right, we're going to get right back into it right now. Right now. Let's turn this off, and we're going to keep the reading going. We've got Daddy Daycare here, so please forgive me. My son is just very excited to be here and join people. But let's just get his head kind of caught up right there. And we got a 6-week-old here. So forgive me, but let's just get into it. All right, where do we leave off? The court has to remind the petitioner twice that counsel would ask a question, and she needed to answer it. At this time, petitioner pushed back her chair and advised the court she did not believe she was being treated fairly. The court attempted to redirect petitioner to no avail. At this time, petitioner became emotional and asked for a brief recess, which the court granted. Now, at this time, we're thinking as we're watching this, going, "Oh man, they had her on the ropes and she got away with it." But of course, what we know now is that the judge knew what was going on and said, "Take the recess. I could use a pee break." Maybe she wanted to take a second there and relax. At the time, petitioner became emotional, asked for a brief recess. The court granted. The court finds this. I'm out of breath. Hold on. I just ran into the other room to pee and put a baby on me. The court finds this interaction between counsel and petitioner diminishes the credibility and veracity of the petitioner's responses during cross-examination. The court finds it is impossible to determine the date of any alleged miscarriage, not because it is impossible, but rather because she failed to seek even a minimal level of care for her high-risk condition. And boo-boo. There he is. Isn't he the cutest? Any the cutest right there. Okay. Failure to demonstrate confirmation of ongoing pregnancy is a purposeful way to ensure respondent would not be able to determine if she was pregnant, and if so, for how long the pregnancy lasted. We continue. Dr. Michael Medchill. Okay, so this is the very credible retired doctor. If you dribble, you shoot doctor. Remember him, the doctor who likes to dribble before and after he shoots. Retired, so they mentioned he's retired, OB-GYN and prior chair at St. Joseph's Hospital, testified that pregnancy is possible without intercourse. Well, we know that, but in most cases, pregnancy happens from intercourse. You know, I'm talking about. Sorry, earmuffs. Dr. Medchill testified that he delivered 30,000 babies during his practice and saw many patients for miscarriages. And again, that number is pretty highly contested from a lot of people. Shannon said, Augie is fascinated by your voice. Yeah, probably because when I'm talking to him, I'm always like, and now he's like, why are you in your radio voice? I'm in my radio voice because we have an arena full of people listening there. Oh, Gus, the gusto. Dr. Medchill testified that, are you laughing? Did I hear the chuckle? Are you laughing in there? Oh, everybody wants to see the baby laughing. Are you laughing? He just learned how to laugh. I know. Daddy doesn't make you laugh too often. Are you laughing? Dr. Medchill testified that he reviewed approximately 200 pages of petitioner's medical records from Barrow Neurological Institute in Phoenix that included summaries of petitioner's medications. He did not, however, review primary care or historical OB-GYN records. That's right. He did not read the records. Okay, Steve's late. Where are you, Steve? I'm sure Steve's scrambling to put a shirt on, as you do here. Dr. Medchill testified that none of the medication records he reviewed would cause a false positive home pregnancy test. Dr. Medchill testified that a false positive HCG test could be the result of epilepsy medication, anxiety medication, clozapine, horse urine, or IVF prescribed injections, trigger shots. Now, there's no way she drank horse urine, right? That wouldn't have happened. But hey, who knows? Maybe it was an accident. You know what I mean? She's changing the hoofs, and who knows, golden showers, who knows what could have happened. It seems the consensus is in that everyone thinks this baby is adorable. I have to agree with you. I mean, I'm wearing my nice manly pouch here. We've got full kangaroo mode. He's as sweet as they come. And it makes getting any work done really hard because all we want to do is stare at him all day. I think, we have another legal vice. We have a vices raid. Hello from the vices, from the Viceroy. Legal vices raid coming in. Hello, everybody. We're covering this story right now. We appreciate the raid. I thought Legal Vice was going live on Wednesday. I was going to try to do his chat. Was he going live this morning? If I missed that, oh geez, now I feel bad. I'm trying to schedule a chat with Legal Vices because he's been so good. Oh, Legal Vices is there. Sorry, Bubba. It's today. I thought I was going to try to go on your channel on Wednesday. I might have been off by a day, but either way, I'd love to go on with you tomorrow if you're going, or the next time. Just send me. I got to give you my cell phone number, because I never check my Twitter messages. But anyway, thank you guys all so much. Let's just keep going here. Dr. Mitchell testified that okay, let's go backwards. When asked by the court, Dr. Mitchell testified he did not review any Planned Parenthood records from Mission Viejo or Los Angeles facilities. I mean, that alone was enough, wasn't it? The fact that he didn't go over those records, and let's see, I think he wants his arm up. Let's do arms up. You want arms up here? So yeah, I mean, the fact that her expert didn't go the extra mile to review those records is absolutely ridiculous. Dr. Mitchell testified that a home pregnancy can detect pregnancy 11 days after conception. Okay, so while it can happen, it doesn't mean it would. Dr. Mitchell testified that he is 99.9% sure that the petitioner was pregnant based on the HCG tests. He did not change his perspective after petitioner's admissions on the stand that she altered more than one test to reflect higher viable HCG numbers. Oh, I love this. I absolutely love that the judge wants to let people know. Well, he didn't change his tune when he got more information, which he absolutely should have. As a doctor, you're a scientist. If some of the data sets have been manipulated, how can you consciously say that this one data set is accurate when the other ones have been manipulated? You know what I mean? The court finds Dr. Mitchell's testimony that 0.1% chance the petitioner received a false positive due to several medications she is in fact taking, possible trigger shot for HCG, and a prior history of ovarian cancer to diminish his credibility. Wow. I got to Legal Vice said you're correct tomorrow morning. All right, I'll see you tomorrow morning then. Sorry, I'm an idiot. Thank you for the South Korean, whatever the heck it's called. I appreciate it. Is it a South Korean? Well, it doesn't matter. Let's read this again. The court finds Dr. Mitchell's testimony that 0.1% chance that petitioner received a false positive due to several medications she is in fact taking, possible trigger shots for HCG, and a prior history of ovarian cancer to diminish his credibility. I'm having a hard time understanding that sentence. I'm going to read that one more time. South Korean wonton. So that can't be right. I just read that. That sounded offensive. Sally said that ovarian cancer lie finally coming back to bite her in the butt, as it should. The court. I'm going to read that one more time. The court finds Dr. Mitchell's testimony that 0.1% chance that petitioner received a false positive due to several medications she is in fact taking, possible trigger shot for HCG, and a prior history of ovarian cancer to diminish his credibility. Is that a proper sentence? Am I reading that wrong? She meant to write diminish. It's a typo. Okay. So what she's saying is she's saying this diminishes his credibility. I mean, look, this is why you can't be an expert and not do expert things. He can never testify again as an expert because now you have a judge saying he's not credible, right? Do I have that right? Especially given that records that the petitioner testified existed were not presented to her own expert for review and consideration. Now, my guess is Mitchell he's retired. I'm sure he's made good money. He probably doesn't want to be like an expert. So he's probably like, whatever, he's just going to be retired. But honestly, I'd love to have an interview with him. Teresa said he wasn't credible before he testified. Yeah, he probably doesn't care, but he should care. Because it's wrong. Whether you're a retired doctor or not, you took an oath to do no harm. And if he's playing a loophole here, he's doing harm because he's not being honest with the facts. He's saying, well, yeah, I mean, you could jack off and the wind could blow it into someone's vagina. You know what I mean? Like it's like, okay, sure. Something could happen. You could have sex in a tornado and then all of a sudden it gets onto another, sure. Yeah. Anything could happen, but come on, let's be honest here. It was bad faith of him. Dr. Medchill testified that a blood HCG level of 102 is proof of a non-viable pregnancy. While Dr. Medchill testified that a non-viable pregnancy is still a pregnancy, the court finds that altering the number to reflect 102,000, it was 131,000, it was in the 130s, which would be a viable pregnancy to indicate that she intended for the respondent to believe that she was still pregnant with viable fetuses. Now, she would argue, no, I only sent that to the journalist to stop harassing me. No, she sent that fake HCG level to me and to Clayton. Cece said, Laura has sent Gingras 700 text messages already today. Oh, I'm sure of it. I'm sure she's going to try to get this stream taken down. Absolutely. I mean, this is wild stuff. Luna said, according to her expert, you can probably get pregnant sitting on a chair. I mean, you could get pregnant playing hopscotch if or what's that game, Twister? You ever play Twister with your friends? Legal Vices with another super chat here. Thank you so much. He said, you worked hard, Dave. You deserve to be rewarded way more than this for your efforts, personal, family, and financial sacrifices. Bubba, thank you. Thank you. I mean, that means a lot. Thank you. I do. After Monday, I have felt the love on such a personal level from so many people. I don't want to make the story about me, but in a weird side, less important way, I, of course, have, is an interesting story. With the wildness that occurred here. Dr. Medchill concluded that the petitioner became pregnant on May 20th and ended with a spontaneous abortion, which again, a spontaneous abortion is a miscarriage, which I don't believe she knew what that term meant, but anyone who's had one does. Late October, early November, or possibly sooner in 2023. Given the alterations of the only records to indicate pregnancy, the court does not accept this conclusion. Wow. So the court is saying, no, thanks. The court is saying, no, sorry? You need my phone? Okay. If you let me know if I get any dire texts. I'm just waiting for him to come on. Dr. Medchill testified that women may expel tissue during a spontaneous abortion, or the pregnancy might remain in her body, ultimately being reabsorbed. Wow, that's that invisible twin. Cece said, I loudly clapped many times during the readings of this. Given that the petitioner testified under oath at a prior hearing that she was absolutely 24 weeks pregnant and had seen her doctor, presumably in person, the court does not accept that 24-week-old twin fetuses would be reabsorbed into a mother's body. Wow. This is incredible that a judge would make these statements. I mean, it's not wrong, but it's just incredible. The court further finds a miscarriage at that stage of pregnancy would result in emergency medical care and corresponding death certificates of the twins. If what Dr. Medchill testified to is true, and she miscarried much sooner, negating the need for the death certificates, then petitioner perjured herself at a prior hearing. Oh, minor perjury. So this is the first mention of perjury here on page 10 of 19. First message. BK said, Judge knows science. Yeah, Judge wasn't messing around. Don't ever lie under oath. Here's some advice for you. Don't lie under oath. Don't ever lie to your mommy or daddy. And especially don't lie to Judge Mata, because Judge Mata will rain down on you. She will rain down on you, and you will get a timeout. Judge Mata will give you a big timeout if you lie under oath. Don't do that. You're not allowed to. You have to tell the truth, especially in the court of law. That's a valuable lesson for our kids out there. 2,953 people. Can we hit 3,000? Julie Ann said, would have loved a chat with the credible Dr. Dean. Maybe we'll get Dr. Dean on the channel now. We know she's a fan of the show. She's the queen of all Planned Parenthoods. We know that. But anyway, Moki says, Judge Mata has a bull poop radar. Let's continue. Waiting for Steve to show up. Where are you, Steve? So they say that either way, she either lied, she either perjured herself, or something went down. Oh, here we go. We have Samantha Deans. Dr. Samantha Deans, MD, MPH, reviewed petitioner's records and provided her analysis of the HCG results. Additionally, she was the prior associate medical director of Planned Parenthood in Florida and Pennsylvania. She testified that Planned Parenthood does not accept anonymous patients. They do not accept patients using an alias. Patients are required to provide a government-issued form of identification. She further testified that Planned Parenthood is not open on Sundays. When petitioner testified, she sought care July 2nd, 2023. Laura said, let's see Nick Vielle walk back his previous statements. Which are you speaking of? Let me know what you're talking about. But we'd love to know more about that. Dr. Deans testified that HCG does not confirm pregnancy. There must be serial HCG or an ultrasound and examination, which were never done or never disclosed to the court, the respondent, Dr. Medchill, or Dr. Deans. Dr. Deans reviewed the July 23rd telehealth instructions that petitioner proceed to an emergency room for additional evaluation and care. The instructions were not followed, but petitioner called the abortion and miscarriage hotline, which also recommended and encouraged the petitioner to seek in-person medical care. Dr. Deans testified that there is no data to indicate a conception date. After reviewing the records, Dr. Deans determined that the HCG tests were never dispositive of pregnancy and that the related miscarriage timeline, which included detailed analysis of the likely origin of HCG in petitioner's blood and urine, was not indicative of human gestational norms. Dr. Deans testified that heterophilic autoimmune responses due to exposure to animals could produce a positive HCG test, but the confirmation blood test would be negative. So, autoimmune responses to exposure of animals. So basically you could get allergies by being with an animal, which could cause a positive. Now, I don't believe that's the case because she knew when she would test positive and she knew when she would test negative. A prior history of cancer could also produce a positive HCG result. Petitioner has a prior history of ovarian cancer that prompted the surgical removal of her right ovary. Now, I don't know if the judge understands that this is fake, that she faked it. Ladies and gentlemen, flying in from Texas, it's the great reality Steve Carbone. How are you?
Oh gosh, what's going on?
Dude, have you heard the news?
Okay, so I started reading and I was in like the middle of the fact finding or finding of facts. And then I got a phone call for 30 minutes and I just got off the phone call. So I was like halfway through the finding of facts. I've never read anything like this. It just seems, I thought it would like go in order of stuff. Like it's just kind of all over the map. I'm confused on what.
Yeah, I'll catch you up. The judge finds her, Laura Owens, expert to not be credible. That's
the last thing I read was MedChill. That was the last part I was on before I got
the judge also finds that the idea that she absorbed the fetuses also not credible at 24 weeks pregnant. So the judge basically said either that didn't happen or you committed perjury. One of the two happened, the judge said. Yeah. Now, what I'm going to read is going to get absolutely crazy. I don't want to share it with you yet. I don't know how much you know, but it's going to get crazier than I thought it would. So I'm just going to pull it up here and interject as you please. And we continue here because we're on the final stretch. Familial HCG syndrome can also produce a false positive HCG test. Dr. Deans testified that syndrome is very rare and with only 10 known cases in the world. Horse tranquilizers can create a positive HCG test. So the judge is just, saying all of the different things that Dr. Deans said. All right, Clayton Echard takes the stand. Respondent denies all allegations of sexual intercourse. Respondent confirms both parties were under the influence of marijuana, but denies being high and further denies memory loss because of the marijuana ingestion. Respondent testified that around May 22nd, he realized his behavior with petitioner was unprofessional and he intended to discontinue a sexual relationship with the petitioner. He testified that upon hearing this, the petitioner became very emotional, which again, Steve, when I interviewed him back in October, he said the same thing to me. He said they were in his car, they were about to go see Holmes, and he said, I don't think that was a good idea. And he said, she literally changed. She became a different person in that moment. So yeah, we know how it is. You know, Steve, you're always turning women down. I saw you.
Oh yeah, left and right. Yeah,
I see how these women get when Steve gives them the old no thanks. So anyway, respondent testified that he told petitioner he had submitted the offers to the seller. They go through this whole part, which again is like,
This is the part before this is where is right when I got the phone call. So this is the part I was just about to start reading. So this is perfect timing.
Perfect.
This is right where I got to.
Respondent made knowingly false statements to Laura about the real estate purchase offers. He's already admitted to this. He was trying to get her off his back. He ended up actually giving her as a client to another realtor within his group. Clayton testified that Jane Doe, Laura, sent him approximately 500 text messages using 13 different phone numbers, threatening to leak information to the media. Respondent testified that petitioner reached out to the son, called his family, coworkers, and prior girlfriends, accusing him of being a deadbeat for not supporting her and the twins. Respondent testified, and by the way, she did the same thing to Greg Gillespie. She did the same thing to Mike Maricini. She calls people. She tries to use family pressure. That's why she got the Iceland trip with Mike Maricini. She called his mom, and his mom was like, "Come on, Laura's a good girl. What are you going to do?" It's just absolutely.
Yeah, when I talked to Mike at the trial or after the trial, he said because I was like, why did you end up going on the trip with Laura? How did it all come about? He's like, oh no, we booked the trip together and then we basically broke up. He goes, I was just going by myself. And then she basically, I don't want to say invited herself, but got back in my good graces literally the day before I left. So I was like, okay, you can come. Like, he was set to go on this trip by himself.
Having met Mike, what was your character assessment of him?
Oh, it just seemed like a super nice guy. It just didn't seem like any, look, and I could be biased because I met him and spent time with him, but just like spending time with Clayton and spending time with Greg Gillespie, it's just like, I just don't believe any of the things that she's accusing them of doing. I just don't.
Beautiful wife too, huh?
Both of them. I mean,
beautiful. Both of their partners, Greg and I only say this not to objectify, but to say they're leading happy lives. They both have young kids and they've moved on, but boy, are they happy that they are now included in this fraud, which the judge is going to talk about the recurring nature of the fraud, which is so helpful to them, because the damage is already done, but at least moving forward, they can point to this judgment and say, oh, read it for yourself.
Yeah, no. And in speaking to them and their wives and knowing they have children, it makes sense as to why you could tell they wanted to move on. Like, they maybe didn't want to get involved in this. I mean, it's kind of been a beat down for Greg. Mike was a long time ago. I can see why he wanted to move on and didn't come forward until he had all the support, like he said, but it makes sense.
And all these little pieces of evidence that came forward in the last 6 weeks, it was kind of like you were kind of the initial, and by the way, this is so funny that you were the one, because you're the spoiler king. You were the one who got the ultrasound, the fake ultrasound, and kind of just forwarded it along to people and let them do their work on it, which everyone, within days found out it was completely fabricated. Maybe that day, which, by the way, she stole the ultrasound from a very niche channel that only had a couple hundred views. Whoever found that ultrasound had to do a lot of digging. So it's just incredible.
Well, and the thing was, when she sent it to me, along with her neurologist report and along with that picture of her standing in the mirror, I just figured she sent it to you and or Clayton in just separate emails. I didn't realize I was the only one who had received that. And I was just like, it was laughable. I mean, at the time, obviously you hadn't proven the sonogram was taken off YouTube, but when I looked at it, I mean, I haven't looked at a sonogram before. So to me, I just kind of glanced at it. I'm like, okay, I guess this is a pregnancy, but little did I know.
Yeah, that's the whole point, right? Is that what man who hasn't had a baby knows how to look at these things? Yeah. And even if you have had a baby, it's at an early stage, you can't tell what's going on there. So
the other two things were in the email, the video, the 3-second video of her standing sideways in a mirror with a belly. I was like, this just doesn't seem like how you would show somebody, hey, I'm pregnant. And then obviously the screenshot of her neurologist appointment where it was one sentence saying, patient says she's 21 weeks pregnant. I'm like, okay, this doesn't prove it. Again, it's 2 of the 3 things you sent me don't prove anything. And the third thing, I don't really know how to read, Laura. So I'm not going to all of a sudden take your word for it that you're pregnant because this is your proof. Because it's like, get on a FaceTime call with me, go live. Everything you sent me is like recorded and whatnot. Just was not believable. Just from the very beginning, like everything from the Sun article to June, it's like,
Judge Steve Carbone of the People agrees with Judge Mata here.
Where's my gavel?
Yeah, I got the gavel for you. Well, somebody send Steve a gavel. We need to get you in a full, cap and gown and whatever, the little British wig or whatever they wear. Okay. Respondent testified he received the video from petitioner and continued to correspond with her over that email string, which would reasonably prompt petitioner to advise she did not send the video, but she did not advise of that at the time. Petitioner Laura emailed Clayton, "You can't say you haven't been given a voice when I have told you that I will have an abortion if we try things out for a few weeks and have a good reason for aborting the child. These words feel menacing because you know I like you and want to try things out with you." By the way, the fact that the judge is summarizing all of this, I would have loved to see what was going down in the judge's like sort of the room where they deliberate. The email continues, "You would be obliging to make the decision to date exclusively before deciding whether or not we have an abortion." Laura can encourage respondent to have sexual intercourse with her, citing she was tight and already pregnant. Now we've got the Greg.
The tight vagina, here it comes.
Here it is. This is what Greg had to say before he brought up the tight vagina line.
This will get awkward.
And it did. Petitioner further emailed respondent that he had control of the outcome of the pregnancy if we date exclusively and care for each other. On June 28th, she said, "If you think about it, having sex with me is the safest thing you can do at this point. I'm already pregnant, and if we choose to go this route and trust each other enough to have sex, then we are at the point where I would be taking abortion pills, so there's no risk." Now, what I love is that she's bringing in evidence that didn't really get it was admitted to the case, but it wasn't really spoken about. And this just goes to show how good this judge is, that she was able to go through these emails and see what we all saw, which is, this is insane.
So this thing right here that we're reading, this is like a 19-page report from Judge Mata about everything. There's sometimes some things that I was reading before we got to this point, which I'm sure you've already covered, where she gives her like opinions or facts. Like these are just laying out facts of the case, but then sometimes she'll interject things. Is that how it works, or is at the ending of this thing she'll give her whole like summary of, hey, this is my whole shebang?
A little bit of both. So as far as I can tell, she's going through each witness, saying what they like boiling down exactly what they said, and then she'll say if it's credible or not. And then combined, what she's gonna say is that everything she said was uncredible. Everything he said, well, she hasn't said anything, but I'm assuming she's gonna see that Clayton was pretty honest here. Petitioner told respondent the twins were a boy and a girl. Petitioner provided respondent with a sonogram that was posted on YouTube 7 years ago. Petitioner admitted to this during her deposition. All right, so she admitted that during the deposition. So this judge is so good. The judge, because we were going, oh my gosh, they didn't bring up some of these points because it was going so fast, but the judge was able to look at her deposition, see that she admitted to sending that video, even though now she's saying Greg Gillespie hacked her account.
Wait, did we know that Laura in her deposition admitted that she got a sonogram off YouTube?
She didn't admit that, but she admitted to sending it. So she admitted to sending that sonogram to you and to Clayton, I believe. And then, of course, she later denied it. Petitioner sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. Okay, so they don't say that that was extortion, but they called it a threatening letter. Petitioner signed a release of records for Dr. Jeffrey Higley, MD at Women's Care. In a letter dated March 18th, the provider advised, "We have no record of treatment for the dates of service you requested." All right, validity of petitioner's order of protection. So this is the judge duty order of protection. This may be the one part that Clayton doesn't get a good answer, but let's read it. In this case, the gravamen of respondent's position is that petitioner has fabricated her pregnancy. A condition, so Clayton's position is that she fabricated her pregnancy, a condition which cannot have resulted from the parties' interactions because, according to respondent, they never had sexual intercourse. But he does admit that the pair engaged in oral sex. Respondent seeks to have the protective order invalidated based on the alleged fabrication, while petitioner essentially argues that even if she was never pregnant, the sexual activity between the two and respondent's subsequent harassing online conduct are sufficient to sustain the orders regardless. There is a predicate issue that should be addressed, which goes to the family or the court's authority to reconsider the protective order at all. Put simply, extant appellate authority, namely Vera v. Rogers, and like cases, precludes reconsideration here. So it looks like that's not going to be a good thing for Clayton here. Mother applied in Vera. Mother applied for a protective order in Phoenix Municipal Court, but it was eventually transferred to the Superior Court after father petitioned to establish legal decision-making authority, parenting time, and child support. And by the way, I just hate this because these court cases they're citing were actual pregnancies. After a contested hearing, the commissioner handling the order of protection affirmed it in its entirety. Father then filed a special action asking the Court of Appeals to order the family court to amend the order of protection to align it with the temporary parenting time orders it had made in the separate case. So it looks like, I don't want to read all of this, but it looks like this has to go through the appeals process. So she's not going to rule on it, is what it seems. But I'm going to kind of glaze through that there.
She's not ruling on what part? Whether or not
overturning the order of protection. If anyone in the chat has a quick answer for me, let me know there. But it looks like that's just one of those things that she's not willing to overturn that until maybe it goes through the Court of Appeals. I could be wrong on that. Petitioner's pregnancy, indeed, his initial order required that respondent not contact petitioner or communicate or post untrue or harassing comments regarding plaintiff online, including but not limited to social media, and shall not cause others to do the same. And again, this is when she thought he was harassing her by posting like little to no fetal DNA, but he never lied. He never lied or anything like that. Laura's initial petition referenced a myriad of communication respondent made to her that could be deemed threatening per the statutory guidelines and appears to have prompted Commissioner Duty to confirm the order after the hearing. Thus, even if petitioner's broader pregnancy allegations are proven untrue, one aspect of the court's order indicated that it found respondent had engaged in harassing conduct. So even on the merits, there is no cause to invalidate the final judgment. And by the way, I don't think Judge Maddow believes that he was operating in a harassing way. I just think it's like, well, they did have oral, and because of that, the rules, even if she made up pregnancy, it doesn't mean, that he didn't harass her. Now, I think that's complete craziness because the Honorable Duty was, operating off of some false information. But anyway, so here we go to sanctions. This seems to be the important part where sanctions will determine who's paying the bill. By signing a pleading, motion, or other document, the attorney or party certifies to the best of the person's knowledge, information, and belief formed after a reasonable inquiry. It is not being presented for any improper purposes, such as to harass. The claims, defenses, and other legal contention are warranted by existing law. The factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. All right, so this is all small talk about what's to come. So in this case, Clayton filed a motion for sanctions pursuant to Rule 26 on January 3rd, arguing Laura Owens filed the underlying action for an improper purpose without medical evidence to support her claim that she was pregnant and or that she was pregnant by a respondent. However, after significant motion practice between the parties, attorneys, respondent filed a motion to withdraw motions for sanction pursuant to Rule 26 on April 3rd, while retaining his other claims. So that's Rule 26 is something they talked about over and over. Woodnick Law said he regretted withdrawing that motion, but did it because I think he didn't want to give them one more thing to argue against so as to simplify this case. But he said he regretted it once he saw that Gingras wasn't going to kind of play fairly. As already noted above, expressly provided that the court can sanction a party for a violation on its own. So this is Judge Maddow saying, even if you withdrew the sanction, I can still put the hammer down on anybody if I see something that's going wrong. So it doesn't have to be one party saying, Mom, so-and-so hit me. If Mom sees that so-and-so hit somebody, Mom can say timeout. You don't have to say, Mom, I would like timeout. You look, Steve, we're idiots. I think that's a good summation of what's going on, but we do have some lawyers in the chat. Yeah, works for me, right? So anyway, so she goes on and on about Rule 26 sanctions. As a matter of plain meaning and strict interpretation, it would seem not to matter whether a party ever files a motion or even whether that party does file a motion and then withdraws it. A court may still award the sanctions it deems appropriate based on the conduct it deems to violate the rule. Now, she's saying all this because Gingras's argument on and on is that this should be dismissed on appeals because blah, 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 blah. Everything was, he jerks off to Rule 26. That's literally, he searches Rule 26 on YouPorn and then just whatever comes up, that he feasts on it because he's so obsessed with Rule 26. But as the judge says, it ain't matter. F Rule 26. Let's just continue. Although there is a dearth of case law on this issue, other rules confirm that the family court has the authority to award sanctions on its own. In a prejudgment or post-judgment proceeding, the court, upon motion or its own initiative, may impose sanctions if a party or attorney fails to obey a scheduling or pretrial order, fails to appear at a resolution management conference, a scheduled conference, an evidentiary hearing, a trial, or other scheduled hearing, is substantially unprepared to participate in conference, hearing, or trial, fails to participate in good faith in a conference, hearing, or trial, or in preparing a resolution statement. So they go on and on about the reasons why she can, throw this down. As evident from their near textual identity. Okay, so again, more case law, non-paternity. Let's get into non-paternity here. A man is presumed to be the father of a child if genetic testing affirms at least a 95% probability of paternity. All right, so we got that. She says, repetitive RAVGen results of little to no fetal DNA. The court cannot establish that petitioner was pregnant. The court cannot establish paternity of a non-confirmed pregnancy lacking DNA evidence despite testing twice. Now, the test was actually done 4 times, but here, 2 test results of little to no fetal DNA fall woefully short of the 95% required to meet the burden of clear and convincing evidence that respondent was the father of petitioner's alleged pregnancy. All right, attorney's fees and costs. We're getting there. Clayton Eckert has requested an award of attorney's fees and costs. An award of attorney's fees and costs is governed, provided as follows. The court from time to time, after considering financial resources of both parties and reasonableness of the positions each party has taken throughout the proceedings, may order a party to pay. All right. Got that. If the court determines that a party filed a petition under one of the following circumstances, the court shall award reasonable costs and attorney's fees for the other party. The petition was not filed in good faith, not grounded in fact or based on law, filed for an improper purpose. So essentially, she's saying if there was fraud, Clayton doesn't have to pay his fees. She does. The court finds, here's interesting stuff here. The court finds there is no substantial disparity of financial resources between the parties. Petitioner did not provide an AFI, but testified she and her mother collectively earned $200,000 a year. Doing what? A respondent filed an AFI on May 15th, citing monthly income of $12,000 and annual income of $144,000. Not bad, Clayton Eckert, huh? Not bad. Again, that probably has to do with some of the windfall from being the Bachelor, and I would not imagine he's expecting, every month for that to be the same, especially since he works really as a freelancer. The court further finds that petitioner Laura Owens acted unreasonably in the litigation. Specifically, Laura Owens acted unreasonably when she initiated litigation without basis or merit, without an authentic ultrasound, sonogram, physical examination, and in conjunction with a belief she passed tissue in July 2023. The court finds the underlying petition premature at best, at worst, however, fraudulent, and made to incite communication, a relationship, or both with Clayton. The court further finds that filing a motion seeking mediation for the purpose of telling the respondent that the pregnancies were not viable, disingenuous at best, but certainly misleading to the court. If the purpose of the motion was in fact to attend mediation, then the petitioner perjured herself today when she said the purpose of the mediation was to tell the respondent about the miscarriage. Wow. So this is the second time that the judge says she either misled the court or perjured herself. Either way, respondent likely incurred costs associated with this litigation prior to retaining counsel, and he is entitled to reimbursement for those costs. The court further finds that Laura Owens repetitively failed to comply with Rule 49, even on order of this court, further compounded by the fact that on the day of trial, she testified that she anonymously sought care at a Planned Parenthood in Los Angeles, while she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias. Respondent presumably sought records from all Mission Viejo Planned Parenthood, as that is where, up until today, petitioner disclosed she sought care. This undoubtedly caused respondent to incur substantial legal fees attempting to locate records that may or may not exist in Los Angeles, but now appear to have never existed in Mission Viejo. Additionally, petitioner acknowledged she altered HCG test results in ultrasound and sonogram. And the court further finds that the provisions of ARS do apply because the petition was not filed in good faith. The petition was not grounded in fact or based on law. The petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. Here, the court finds petitioner provided false testimony as to the viability of the pregnancy in all three cases addressed in the procedural history. Wow. Additionally, prior to her deposition, petitioner sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. Oh boy, it's a lot of words, but it looks pretty good for Clayton. The court further finds that Laura Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery such that an award of attorney's fees and costs is appropriate. Steve, how does it feel? Let me take a quick sip of coffee here. How does it feel knowing she called you a liar, called me a liar, said we were all delusional? Her lawyer says we're all part of a crazy cult, and now the judge is saying she lied.
I love it. Look, we knew this was coming. We knew Judge Mata, just based on striking down every single thing that Gingras brought to the motions that he filed. We knew this was coming, but it is great to get the validation. It's almost like when I give a spoiler out and I can't really prove it because I can't give up sources, and then the finale airs and so-and-so picks so-and-so, like I said months earlier. It's like, yeah, I knew, and now I'm validated. This is basically the same thing, right?
There's only one word when that happens. It's called boom shakalaka.
Yeah.
Boom shakalaka. But wait, there's more, Steve. We're just getting to the fun part. This is like if you're ever with a lady and it's like crazy moves are happening and then you think it's all done and she's like, then she pulls out the bag of goodies and then, and then she takes you out for pizza after. This is the pizza party part. The court further finds she presented a false claim. We got that. It is thereby ordered granting Clayton Echard's request for attorney's fees and costs associated. It is further ordered denying Clayton Echard's request for attorney's fees and costs associated with the OOP and IAH hearings, referencing the analysis above. So they deny his request for money for the IAH and OOP. But again, that was kind of just like, they're going to get whatever they can out of Laura. So that's kind of not that big of a deal. It is further ordered that Laura Owens shall pay Clayton Echard's reasonable attorney's fees and costs, not later than July 8th of 2024. Oh my gosh. She owes it into the day of the Bachelorette premiere. How about that? What timing? July 8th. She owes Clayton all the money he is owed, however much that is, in literally 2 weeks. Listen, if she needs to come forward and make some money, I hear Fiverr is hiring. If anyone wants to hire her for her services here. It is further ordered. So she has to pay Clayton's reasonable attorney's fees no later than July 8th. Clayton and counsel for Clayton Echard shall submit all necessary and appropriate documentation to support an application for an award of attorney's fees and costs, including a China doll affidavit and a form of proposed order. By no later than July 29th, Laura Owens shall file any written objection in a form of proposed order. If Clayton Echard's counsel fails to submit the documentation by July 8th, no fees or costs will be awarded. The court shall determine the award and enter judgment upon review of the affidavit as well as any objections. So what that means is everybody's working overtime because every single receipt that Isabel Deandra Woodnick has on this court case is going to be paid by Laura Owens, and they're going to make sure that they've got the bill rung up nice and high. My guess is, but let's take a guess. Let me ask you, all right, put a number in your head. What do you think the cost is going to be? Again, it's just this case, not the IAH, not the OOP. Give me a number. I got a number that's coming to me right now. Let me know yours.
Well, I don't know Woodnick's hourly, but assuming he took the case over right in the beginning of November, right after that first, when Clayton defended himself. And then we got Clayton $10,000 on the GoFundMe. So we're talking November through June 10th, where it was literally daily filings and all that.
And we've got Deandra, Isabel, Woodnick, their expert, the costs of, all these other, so.
I don't know. I gotta say, I say 2 to 250.
Okay.
250,000.
All right. Yeah, that's right in line. I went with 162 right there. 162. I have no idea. I'm an idiot. I don't know.
I know it's 6 figures. There's no way this isn't under 6 figures. You work on a case for 7 months. There's absolutely going to be in 6 figures. Absolutely.
Yeah. And hopefully, Woodnick can give himself a pay raise. You know what I mean? Yeah. They put a lot of work into it.
But the question then becomes, let's just say the number's 150. Let's just call it an even 150. There's no way Laura Owens is giving Clayton $150,000 by July 8th. It's not going to happen.
No,
right?
but it looks like she'll have an objection, so maybe that'll delay it. I don't know for sure. We'll have to see what any lawyers have to say about this. We'll get some information here. It gets better. It actually gets better here. Additional orders. But wait, there's more. It is further ordered granting Clayton's petition for non-paternity. It is further ordered the court having determined that Laura Owens has a pattern of similar, if not identical, behavior and court involvement, referring this matter to the Maricopa County Attorney's Office for review of Laura Owens' actions.
So she's now been referred to the DA.
Yes, I think they call it a county prosecutor maybe, but same thing. So the prosecutor can decide, I guess, not to look into this. Yeah. I'm hoping maybe what we'll do is put together a nice petition so that they'll see how many people want the attention that this deserves. I feel like a petition might be the proper thing to do here. But her sort of game of draining people's bank accounts will not work with the county prosecutor. They will have the funds needed to call. I mean, look, they don't even include the other fraud here. Chase J. Jones. This is all stuff proven to be her. So there's so much that didn't make this court case. Mike Maricini, Greg Gillespie. I'm assuming because the judge mentions a pattern here that they will be brought into this, and maybe they'll finally have their story told. So the fact that the judge is willing to mention a similar pattern here is so big, because all along she's claimed, even up until like 2 weeks ago, why does Dave Neal care about my personal history? None of these cases have anything to do with each other. I have active orders of protection against them. She's hidden behind the side of the court that allows her to get orders of protection like it's a free koozie at a hockey game. And now we've got a judge saying, nope, these are all similar. So we knew it, we believed it, and that's what they said. So let's see if there's anything else here. That might be it. The court must decide the amount of attorney's fees and costs to be awarded, but finds there's no just reason to delay making a final order. So I guess Woodnick will say, hey, we need $188,000. She'll review all of it. And if there's any, I don't know, company picnic, she goes, all right, cut that out. Like if there's any, receipts that she doesn't want, she'll cut it out. But my guess is
who ran to Burger King and put it on this docket for how much Laura Owens owes. Yeah. So basically
company massages, maybe. I mean, I don't know. I mean, they probably got very tense here. So I could understand some company wellness programs. It is therefore ordered, pursuant to Rule 78B, Arizona Rules of Family Law Procedure, that this is a final judgment and it shall be entered by the clerk. The time for appeal begins upon entry of this judgment by the clerk. For more information on appeals, see Rule 8 and other Arizona rules. Further order denying any affirmative relief sought before the date of this order that is not expressly granted above. Signed.
The Honorable Julie Mata. Great Julie Mata.
Unbelievable stuff. Now, I'm already hearing that her attorney is crying.
Oh, so you see what he said on Twitter? Oh, this is like halftime of a football game, and there's a bunch of flags on the field. We're only halfway there, folks. This is not the end. Shut the fuck up.
I mean, look, I get it. He wants to continue getting paid, but will they continue to foot the bill here? He said, is the ruling really not public? It should be available online. Maybe I should emulate Clayton Echard's fans and beg for super chat tips to post it. Nah, that's beyond sleazy, even for me. Can you imagine this guy? What a slime. You know what's sleazy? Taking on this court case. How desperate do you have to be? He said, despite what you may think, I really do try to take the high road. Really, I do. Seriously. But I'll go ahead and take a walk on the other side once. First $50 Venmo donation gets the ruling. All proceeds donated to charity. So again, we already have the ruling, but that's what he said. He said this post was sarcasm. Don't send anything. So here's
where his that was. Oh, you just scrolled over his
this is
answer
it?
to the ruling.
Afternoon in Florence. I've read the ruling and have some comments about what's next, but no rush. Appeal will be filed shortly. This isn't over, not by a mile. More accurate to say it's halftime with multiple flags thrown. Calls will be reviewed by higher levels. Listen, the Celtics had halftime yesterday, but they were still up by 20. You know what I mean?
Yeah.
Golly. So this part's wild. The fact that he considers super chats to be begging, like this is the part that's really offensive to me. Super chats, and again, I'm not even asking for them. We got a lot coming in. This is people's saying, I've appreciated the time, and here's an exchange for your time. It is really like the most fair form of capitalism that exists. You know what I think is sleazy? Somebody who's taking advantage of a mentally ill woman. That's what I feel like is happening right now.
Well, and I just want to say this. I haven't been on all your chats, your super chats, but as far as I know, you've never asked anybody here in the chat, please donate, please give me money. Like, this is all, you've never asked for it. You're doing a chat. People know they can donate if they'd like to. They don't have to. Way more people don't donate than do, which is fine. You're not asking for anything. So for him to say the phrase beg for super chat tips, it's just a flat out lie. He doesn't even know what he's talking about.
Yeah, no,
beg for tips.
And we've obviously said it as a joke, like call it breadstick money. We've said it as a joke, but it's like, yeah, we make these videos on an ad-based platform, much like podcasting. Of course, by the way, 3,000 people in the chat. If you aren't familiar, I know just about everyone is, but if you aren't familiar with Reality Steve, vote with your subscription button and go subscribe to his podcast. I mean, he is the godfather of all things Bachelor and reality TV content. And without your support, truly, I'm alone up there. And who knows, videos don't, get deleted. Who knows what happens if we didn't have at least the two of us out there before Megan Fox and her band of nitwit lawyers, I say that respectfully, come forward and start mocking this case because, we're not, legal experts. We just have our intuition to go off of.
You've been doing this live for 2 hours now. Has August made a noise yet? Has he done anything?
Yeah, he was crying earlier, but he came to me about an hour in when the wife had today was the day where she was like, Dave, I need you to watch the baby. I have this, she has a deliverable for a company. She had to post. And I was like, all right, well, put him in the pouch.
And it happens to be the day that Judge Mata's verdict comes down.
I know. Well,
he's been good. I mean, I've been on for 30 minutes. He hasn't made a peep yet.
He's what they call cooing. This is like the sounds of a pleasantly, sleepy kid, but he's been cooing. But look, I don't know. I mean, I don't want to keep you here, but I don't know what else to say. I mean, we got Gingras' thoughts here. He says, despite what you may think, I really do try to take the high road. All right, so we already got that. So did he say anything else? I guess we can go and see what the comments are.
The comments are absolutely destroying him when I looked at him, and that was an hour ago. They're killing him for what he said.
Are these will you sign our petition to no, that's something else. Asking nicely, I prefer to read than you lost and now your Fifi are hurt. I almost thought you sabotaged any win she might have been able to finesse on purpose because she is a bad person who deserves to lose. My head gave you way too much credit. Really enjoyed the return of Rule 26. It's hard to pick a favorite, though. Do you think she filed a bar complaint yet? Someone said, we love that breadstick money. Yeah, I mean, imagine the idea. It's like I'm giving away content. People can watch ad-based or they can watch for free. They can join the premium version and watch this without ads. But yeah, the idea that I am immune to financial shame when it comes to what goes on over here. I share my PayPal. If someone wants to donate, when my legal costs came in, people begged me to have them start a GoFundMe. They said, we don't care what money you make. We want to be able to defend you. And 3 of my audience donated $1,000 each. These are people that wanted to help. I don't want to say their names publicly, unless they want me to, but they were like amazing supporters. And
did you get a $99 donation? Was that 99 by one person?
What, just now?
I'm just looking at the top here. I can see in the chat, I can see $4.99, $5, $25, and then it says
there's some good ones. I mean,
$99.99, $100.
Listen, we need to get you on YouTube fast. So let me control, like, make Fox and I can help you out with this. You already got everything you need. Every time
I signed up for StreamYard this weekend. I just got to figure out which plan I want to get or whatever. But yeah, I just need to know. Like, I'm just not good with like graphics and like something like this. Like when this 2 hour or whatever, how long you go, when it ends up ending and then it saves, is this what you post? You then take this video and post it to your YouTube channel?
It's just, it already is on YouTube. It just stays.
Oh.
It just lives there.
See, that's where I'm confused. I don't know how the StreamYard versus YouTube work.
This is what is your YouTube, by the way? I know you have one. Is
yeah.
it Reality Steve 24?
Reality Steve 24, yeah.
All right, so look, I mean, let me pop it up. So people, we got 3,000 in the chat.
I've got no videos on there.
No, but that's okay. You've already got 1,000 subscribers.
Look at, last time I posted was in 2016.
I'm telling you. Yeah, you would be fantastic here because as you see, you'll have a comment section that's ready to talk to you, and you don't get monetized until you're at 4,000 watch hours. My guess is you'll get monetized in like 1 or 2 streams, and then when you have a big spoiler, it might be an extra $1,000 for you to spend on slot machines. So. There you go. So anyway, folks, go bump up there. Oh, look, I'm not even subscribed. Now I am. So you just got lucky 1,000.
Now I got 1.1 million, 1.1. I got 1,170 subscribers. How about that?
And subscribers really don't matter. Once you're monetized, my channel made as much with 7,000 subscribers as it does with 80,000. So subscribers really doesn't matter. It's all about who's actually watching. And whenever you have a spoiler, if you like tease it on Instagram and then say, go live with me, I'm going to reveal a spoiler. You can milk that puppy so hard. As Gingras says, you'll be begging for super chats. But again, it's just your fan base wanting to give a little response. That's how.
Can you click on videos? I want to see if that was the last.
Yeah, 7 years ago.
7 years ago, podcast number 4 teaser. God, that was the.
Oh, look, you had a Nick Viall one-on-one date.
Yeah. Look, I used to post it on YouTube. That's crazy. Look at that. Oh, this is where her top kind of comes off. Danielle Lombard.
So this was private footage that someone sent you?
This was her one-on-one date that was public. Yeah. And
who's Danielle?
Danielle Lombard, remember? She was on the seat. She was, go back to the video. This is actually funny now that I look at it. Go back.
Hold on.
To my main video, like all the video. Second annual Reality Steve contest. That was, so you remember, I didn't even know you at this point. You were, and this was me. Recording in the hotel room where the party was. That's my mom.
Reality is what folks have to understand is you have such a loyal audience. For those that don't follow, let me give us a Steve sales pitch. For those that don't follow Bachelor, give Steve a follow. It's interesting reality TV commentary. Like what you do, you've got your chops from working on Jim Rome. You worked in radio. You do sports. You have your own podcast. You've been so helpful with me. And I just think that while you enjoy your podcast stream, I think what we're doing right now, like we could both, like we could both be simulcasting this on each of our channels right now if we wanted to. So, you'll be good. I say get that going. And then whenever one of us has a live stream, we just text the other the link. You pop on. Augie can hang out and.
I just need to know how to pop somebody on, I've got a camera. See, right now I'm not talking into a microphone. You are, but my microphone is right here where I record my podcast every night. So how do I make, like, this obviously isn't going to do, but how do I make this my sound?
It's already working.
Without it, because it's picking up the microphone mic.
No, it's picking up your good microphone right now.
Now it is. This is.
Yeah, but it's a little hot. We'll work on this. But it sounds like you might just.
But I haven't been using that microphone. So now it's picking up the microphone from the camera, which is right above my computer.
Yeah, well, so if you go down to settings, it'll show audio, and then it'll show you what your default microphone is. But it might be set to that microphone because it sounds pretty good.
But that microphone is probably 2 feet away from me right now.
It's still, I don't know. It sounds good. You sound fine.
If it's picking it up. I mean, my levels on my mixer here aren't even moving when I'm talking. But if I talk into the mic this way, now I see the levels moving. But
yeah, I would say if you could split the difference, it'd be like 6 inches away from that mic. It sounds really good.
Oh, okay. See, that would be something I would need to be walked through to go through settings and all that stuff.
All right, I'll walk you.
Yeah. I need to have my handheld.
I want, because I've only been using this software for the last few months, and it's web based, so like you can just, you don't have to. They've really made it idiot proof. You don't even have to add graphics. But like what you can do is you can present, like if you have a spoiler image or a spoiler video, you can present that and pop it right in. And you could go live with people. You could literally be live on this and also on your Instagram live and just run the chats. But anyway, I don't want to be the babies.
This is all stuff new to me. But basically, today's a good day because the judge said, Laura, you were never pregnant, and you owed Clayton all his money, or attorney's fees, whatever that number is. Do you think we'll ever know as the public what it is? And
yeah. I think that'll all be public. I think that'll go through the system, like a full audit. And like I said, it's going to be somewhere in the 6 figures. And what I find interesting is wondering how much weight does the judge's recommendation to the prosecutor have? And we don't really know that, but we'll find out.
And then I think based on, conversations that were had behind the scenes, Woodnick said when this is over, when Judge Mata rules, he'll come on with us or one of us. And I figured we would just do it simultaneously, and I would record that and use that as my podcast for the week. So we need to get that arranged where we can get Woodnick on. And I know that the audience wants to hear from Woodnick. And he said behind the scenes, like, hey, I'll come on with you guys once Mata rules. So I think we should start looking into that, or at least reach out and see, like, hey, when can you do it?
Yeah. And it might be, who knows with the appeal and all that.
Yeah.
Like, we'll have to see.
Does he? I didn't know. I got the impression that he said he would come on once Mata rules, but now that that Gingras is going to appeal, but now that Mata ruling is out there, like nothing can change with this ruling. It can only just be appealed and stuff like that. So it seems like that Woodnick would be able to talk about this now.
Yeah.
Now it's out there.
Right. His job is done. Now, the job of the public isn't necessarily done because, she is setting herself up for a lawsuit for distress. She claims she's lost, like literally 30 or 40% of her body weight. She went from 130 to 90. That's insanity. So people are still holding her accountable. Here, this post on Twitter, on Reddit, shows videos of Jane Doe falling off her horses, knocked out cold for several minutes, taken away in an ambulance. So like clearly she's, I don't want to say damaged goods, but she's taking a couple of hits to the head here. And I think, again, Bruce in the chat said it best, that the only winner on an appeal is going to be her attorney. He's going to get paid. She's going to lose. He's going to talk BS and post online about how Clayton's crazy cult, and he's going to say all these things. Meanwhile, the judge clearly thinks what he did in court was wrong. Other attorneys have spoken. Omar from the Tilted Lawyer said he thought that he did a terrible job, that Woodnick's side was a masterclass in cross-examination. And he didn't have much to work with, but his ability to get under people's skin worked against him, because it really, like, I hate to say don't fuck with us, but like, honestly, Bachelor Nation, LawTube, you, me, we are the wrong people to try to instigate, because we've monetized our ability to talk about this, and therefore we have the financial incentive to see this thing through. He's trying to shame that incentive, but I'm sorry, that's the incentive that had justice come to us in this case.
Yeah. And she absolutely, I don't think ever thought in a million years when she went to the Sun in September of 2023 with her story, because she got away with it with Mike, she got away with it with Greg. I don't think there was any thought in her head that she wasn't going to get away with this, and it was just going to be the same thing over again, and she was going to somehow coerce a guy. But she had no idea the strength of Bachelor Nation fans that were willing to go to the ends of the earth to find all this wrongdoings that she's done in the past. Like, there's no way she ever thought about this, or else she wouldn't have come public with the story.
That's what's so funny. If she did this to a guy who had a all male fan base, I don't know if they would have done this, but women, I mean, to completely generalize, women love digging deep. They love research. They love like Laura is atrocious to the feminism movement. And I don't want to give her credit and say she's pushing it back, because I still believe in critical thinking skills. And I think people are smart enough to know that this isn't a normal situation, but she weaponized cancer victims. She weaponized the Black Lives Matter movement by trying to cancel Clayton with a fake Chase J. Jones account, which we proved. She weaponized, and she used an Asian doctor to fake her cancer. She used a Jewish agent to fake a contract to keep Mike Maricini dating her, a $250,000 radio bogus contract. She weaponized the Me Too movement. Even before Me Too movement even existed, she was riding the ass of women being, the victim here and men not being believed. And she, and sadly for her, she flew too close to the sun, but it, metaphorically hilarious, because it was because of the Sun magazine. And she's now going to have to pay the price. Very basic. It's her consequence. And whether she threatens to kill herself, we hope not, but whether she makes all these threats or whether she admits to it all is really up to her at this point.
I've said this a few times in the last couple of weeks, ever since the trial on Monday, and I'm going to say it again, because as I glanced over to the comments, somebody said it as well, and I want to point it out. This comment by Mochi at 11:58, so just a minute ago, is that it is amazing during all of this, from the time this thing was reported, and that's the comment I was talking about, as much reporting as you did on it, and Laura complaining about your reporting, like, why is this guy doing 2 to 3 videos on me a day? It's, it's crazy or whatever. And then the reporting that I was doing on it every time I brought it up on my podcast, from September of 2023 to June 10th of 2024, when the trial took place, you would think, with as much people that were talking about this case, 2 names in Bachelor Nation like yourself and myself, you would have thought that one of her friends, or a sister, or a cousin, or a third aunt once removed, would contact me or you and send one email that said, hey, Dave, or hey, Steve, I'm Laura's third cousin once removed. And just to let you know, this reporting that you're doing is totally wrong. Laura's in the right. You have no idea what you're talking about. I know her. Even if they were just being biased because they know her as a person and didn't really know any facts, and they're just saying, there's no way Laura would do this. I don't know any facts, but there's no way Laura would do this. We never got one person in 9 months to email either of us from her side to say, hey, guys, you shouldn't be doing this. You're wrong in your reporting on this. Laura would never do that. Not one person. That spoke volumes to me, because if it was reversed, if something that I was doing stuff like this or something like that, or you would, I guarantee people would come to your defense. Nobody came to Laura's defense, and I don't count her dad's Facebook post, which she clearly wrote herself, because the guy's incapacitated in the hospital. I don't think he's writing Facebook posts saying my daughter's being bullied. I don't count that as a defense.
Yeah.
And her mother, while her mother was at trial, her mother has never come out and spoken about this publicly to anybody. Not one friend. Which speaks volumes. Not one person in 9 months ever came to me and you and said, you guys are wrong. Shit, I'll say something about The Bachelor. I'll release a spoiler, or I'll say something negative about a contestant, And within the same hour of my podcast or my article going up, I'll have somebody from that person's side, as biased as they may be, say, hey, you might be taking this a little too far. They're not like this. Okay, makes sense. And that's just me saying something about, hey, this guy's a villain on the season. And then I get somebody responding in their defense. This is 9 months of this woman being crucified by me and you online, and nobody came to her defense.
I had that with Queen Victoria, the villain from Matt James' season, Victoria Larson, where I had one of her friends go, look, dude, you're going a little hard on her. She's not that bad. She's fine. You know, so yeah, you're absolutely right. And by the way, we do have an update here for those wondering. People are asking, your YouTube channel has a new 80 subscribers, but to be quite honest, it's not minute to minute. So it could be even higher than that. Yeah, another 10 right there.
I had 1.17, so I had 1170, and now I have 1290.
Oh, there you go. So you're over 100 new people.
Yeah, 120 more. Thank you. Appreciate everybody. Yeah, I got to start doing it. I just need to sit down with Dave and or Megan and just kind of get walked through on how I go about doing it. Maybe I'll do something later on this week. Just do a StreamYard like test, test run.
When you do it, just let me, Meg, let us all know, and then we can each hop in and join you, and then it'll help, push you to the algorithm. You just got to coach the algorithm. The algorithm wants to trust you. It wants to know, all right, this guy's not going to go away for 7 years. So I'm not gonna do a video once every 7 years now. No, but once it trusts you, like, then it's gonna be like, all right, this guy's he's here, and who knows? I mean, you could absolutely blow up with all of your spoilers, and then like all your tag words, like YouTube will recognize, like, all right, Reality Steve spoiler, send it, because you are a trending tag word on YouTube.
Well, so the thing that I think ultimately what I want to get to is my Thursday weekly podcast. That's the interview one that I do every week. To have that also in video, like a lot of podcasters do. They have video, and then you can have the audio. So ultimately, 4 times a month, along with anything else I want to do on StreamYard or whatever, if I want to go live or whatever. But ultimately, the goal is to start out with my Thursday podcast now being also in video form. Like a lot are. So I don't know, 4 YouTube videos a month enough for them to get you as part of the algorithm? Or?
Oh, yeah. Once they know, it's Thursday, Steve goes live, like whether it's weekly and some people only do 1 a month, but as long as they know that there's some sort of schedule, then they go, okay, this is worth sharing. But in the Bachelor world, you've already got such a name recognition that you're going to get boosted by that way anyway.
Okay. Yeah, no, I definitely need to get on that. I just need to be more diligent about it, but I am going to do it. And I guarantee I'm telling you right now, I will do some sort of StreamYard live like this at some point later on this week, just as a test run, and just to thank people and to say, hey, we're doing this. Oh, look at that. Another 300 people.
You can also do, if you want, you and I can just do a private live so that it doesn't go out to people, just to work the kinks out.
Oh, okay.
But
either way.
And the next thing you know, you'll be going live from the Venetian. You'll have your own. By the way, I gave up carbs after that weekend. It was too much for me. I had a bloated uterus.
At the party? What did you end up? You got to the buffet, or the appetizers. What did you eat at the party, or did you not?
I had all the pizza. I had like macaroni. I had and then on the way out, I grabbed some to go. I was stuffing face.
I was just so in the moment and, shaking hands and kissing babies that I literally had 1 triangle of the chicken quesadilla and 2 of those the potato spring rolls. And that was it. That's all I ate in 3 hours of my own party. Like, I was bummed that I didn't take more advantage of the food situation, but the food on Saturday at the Cabana was obviously enough. That was quite
unbelievable. Unbelievable times. Your party sells out. We got to do a live show, maybe in Addison. We got to figure that out.
Yeah, no, definitely. Addison is definitely the big. It's probably the best one out. There's Hyenas in downtown Dallas. And there's Hyenas all over the country, right? That's a famous.
Yeah, but the Improv is an A club. Hyenas is definitely like a B- club. But I mean,
the Addison Improv is the biggest club in the Dallas-Fort Worth area. That I've seen Nikki Glazer there. I've seen Whitney Cummings there. I've seen Jay Farrow there. I've seen. Well, every time I go, that's the place that I go, and it's the one time I did a live podcast. They flew Olivia Caridi out, and Olivia and I did a live podcast there on a Tuesday night.
I hear her mom lives in Nashville.
Yeah.
We'll have to get.
She can't. Her mom came out for it. We had about 80 people. I think we had 70 to 80 people in the audience that night on a Tuesday night. And because for comedy clubs, Tuesday night, it's like it's the one night where you can get stuff in, because they always have what's going on. Tuesday night.
We did 150 in Scottsdale, and I think over 100 in Seattle. So I think you and I together could put together a fun show, and then maybe we could find like whatever the local bar is after. But we'll talk more about that. I don't want to take up any more of your time. Thank you so much for joining us today. Your live count is you're up to over 1,300 on YouTube. So folks can go find Steve right now. He will be going live. We are holding him to it. We're not letting him. You will be able to donate Olive Garden breadstick money to him. So
I don't even know how to do. I don't even know how to set that up. Do I have to set anything up on my end for people to do donations or?
Well, you have to get approved to be a not a content creator, the creator program, and that will come when you hit 4,000 watch hours. So right now, like this video is going to be 15,000 watch hours. So if you have a video going live, it's like how many watch hours per person watching. So you'll hit 4,000 within a couple days. I mean, my channel, it took months, if not years to hit. You'll hit it fast. And then from that point on, you're now getting monetized with everything you do. So
this video itself is going to get 15,000 watch hours.
Let's say I make a 3-hour video and there's 3,000 total people that watch it. That's, what is that? 9,000 watch hours right there. So that's, yeah. So, and then this is only live. People will watch this afterwards.
But it doesn't mean they have to watch all 3 hours. They just have to tune in at some point.
Per minute, however many minutes they watch, it adds it all up. So live streaming is a great way to talk your way into the 4,000 watch hours. You already have 1,000 subscribers, which is the other. And in fact, it might be lower than 4,000. Either way, you'll get it. You'll get it in 1 or 2 days. If there's any sort of whenever you have a spoiler. I mean, look, your Instagram's great, but Instagram doesn't monetize. So you could do those spoilers on YouTube and then drop them on Instagram and drive traffic. So
same with Twitter. I mean, I release spoilers on Instagram and Twitter basically for free and on my podcast, but my podcast is, it's just obviously the more listens you get, the more money you can make. So that's where I kind of monetize it. Steve, please make your first video a short clip of Laura Owens saying, "Reality Steve called me a dumbass." Did she actually say that in a video?
I don't know. No, she said it in a email, I think.
What?
But she's given quite the amount of clips. But all right, I'm gonna read these super chats, so I don't want to bore you with that. But thank you so much for stopping by, and I'll text you afterwards, and we'll get you set up.
Yeah,
do you want to commit to a time right now for this audience or no?
I mean, what would be? Let me see. Maybe Thursday night. Would Thursday night work for you?
I'm on. I have a show at 7. So not for me, but we'll talk. So everyone can subscribe. But
sometime this week I'll do it. But obviously probably later on in the week since today's already Tuesday and I haven't started doing any of this stuff. But sometime this week I'll do my first StreamYard link.
Oh wait, someone says that there is a fake cry video that you might be mentioned on. Someone said the Facebook video she did. All right, well, send it to Steve or myself, and we'll get.
Yeah, email it to me at steve@realitysteve.com because I don't think I've ever seen this. I know I called her a dumbass in one of my podcasts, but that was like months ago. I didn't realize she referenced it. So if you have it, please email it to steve@realitysteve.com.
I never watched the video because it was so batshit. I didn't want to, but we'll have someone will send it to you. Dude, thanks again. And
we won a lot. Clayton won, but we also won. We're vindicated.
We got a trophy for you right here. We'll send you right.
There we go.
All right, buddy. Take care.
Right.
Reality Steve, everybody. Oh, amazing, right? How great is that? All right, I'm going to go through some super chats because you guys have been fantastic. Don with $10 says, Dave, your integrity, decency, and kindness have been a beacon in all of this mess. Oh, I think I already read that one. Thank you. The Tiger and Phil show gave $10. Thank you so much for that. And by the way, I am going to be going live on Patreon almost immediately after this at 12:30 Central Time. I'm going to go make some eggs and then go live on Patreon, patreon.com/Dave Neal. We're going to continue talking about this. I fully expect there'll be more tweets to go through and this and that. Ileana, $2. Thanks for your integrity in pursuing justice. David Olson with $10. Thank you for the super sticker. I'm so happy for Steve that I just had Reality Steve on. Did we get any messages? Do you want to come in here? Even off camera? You want to come off camera real quick? No? Are you okay? Do you want to make us a cold brew? Are we getting text messages? Caitlin just talked about Clayton on her live, promoted her episode with you and told everyone to watch your YouTube and listen to the Rush Hour. Oh my gosh, that would be amazing. Let's go see if Caitlin Bristow. Oh, we love Caitlin Bristow. Found out that CaitlinBristow.com Caitlin Bristow. I don't know why I can't always find. Here it is. Here's Caitlin Bristow's page. Let's see if it'll pull up. 1 second, guys. Again, we're gonna have a lot to talk about. Look, I don't base my friends off of who's, people. Oh, she's messy. Good. I prefer my friends to be messy. It means they wear their heart on their sleeve. And Caitlin Bristow has been such an ally. So they said she posted this on her live, but I don't know. I'm having a hard time. Oh, it's making me log in, and I'm just having a hard time with that. Let's see if she said this right here.
She's drinking again. I don't care. It's low sugar. And
that's a Spade and Sparrows reel. I wonder when her episode is going to drop. Oh, it's not letting me log in right now. Let me go back to this in a minute here. I'm going to try to read these. Oh my gosh, Boxing for Life with $100 donation. Oh, thank you, honey. No, it's not. But is that your cup or mine? Okay. Can I have it with cream? Thank you. Says, thank you, Dave and Judge Mata, for all the justice. People you may never know, ever meet, have prayed for you. Tasha, baby, and all her victims. Thank you so much. That does mean so much to hear. I accept prayers of all forms. Positive energy is accepted. If anyone has loving energy, positive energy, happiness, we are here to accept it. Thank you guys so much for that. Shannon with $5. Dave, you've been the foundation to build this win for justice. So happy for you. Clayton, Greg, Mike, and the other untold survivors. Let's see who else we have here. B, $10. People are often bystanders during injustice. Thanks, Dave, for having the courage to be an upstander. And to sweet Tasha, dealing with this couldn't have been easy. Thank you very, very much, B. No, I owe Tasha a spa day because she has been a saint. It is not easy trying to navigate all this, motherhood and things like that when dealing with, dealing with a lot of the muck here, the threats. I'm having a security code sent to me so that I can log into my account. Here it is. Give me 1 second here while I look this up, and we're going to see what Caitlin had to say. Getting Caitlin's endorsement has been unbelievable for our channel, and we appreciate it so, so much. I mean, I can't even explain how important it has been to have folks like her. Pammy, how dare you compare Gingras to my beloved Carlton Fisk, Red Sox Nation? No, of course. The only thing they had in common was they were flailing their arms. Carlton Fisk hit a home run. Gingras struck out. Laura, $10. Dave, best day ever. Thank you for all you've done to cover this case. Thank you so much for the super chat. And Legal Vices, all right, we already got that. We already got Legal Vices. Julie and Morrill would have loved to chat with the credible Dr. Dean. All right, I'll work on it. We'll see. I don't know if she'll be able to talk publicly, but we will try to get her. Juliet's £5. You deserve more for helping you left your new baby, which is hard. It was hard, but we knew we needed to be there. My wife knew that. The baby knew that. We knew we needed to be there. All right. Laura says, let's see Nick walk back his previous statements. We have a breaking news cold brew coming in. Yeah, Steve was on. He's going to start his own live channel. Are you doing okay? Did you get your thing uploaded? All right. Well, that's a good cold brew, honey. Hey, honey, we're being told right now that Caitlin Bristow was shouting us out on her live stream. Yeah.
Anyways, I thought maybe in the morning you want to show off? Okay, well now
Maybe it's, I don't know where it is. Maybe, oh, she's live right now.
Again. Why do I feel guilty? I've worked so freaking hard. I got a G-Wagon, and it's a matte pearl white color. I am obsessed. And it's just so sick. It's a brand new 2024. The old G-Wagons, I didn't love the way they drove because they were a bit clunky, and my Bronco already drives really clunky. So I was a little nervous about it. But the 2024 Mercedes drives so smooth, and they made the car bigger, and it's freaking amazing.
Let's just see if she comments
I'm
it.
so happy and proud of it, and it's amazing. Thank you. G-Wagon in Minnesota.
She's got so many people following her.
Hi, Dave.
Oh.
Oh my God, some of you are so nice. Yes, Dave, I heard. We need to pop champagne. Fucking justice for Clayton. Good job, Dave, on everything you've done to help this situation. We did it, Joe. It's amazing. I am so happy for everyone, including you, Dave. Go Oilers, my gosh.
All right. So let's get out of that.
I see another doggy.
And then we'll do a few more super chats.
Oh, you want to see the G? You want to see the G-Wags?
So Caitlin Bristow just bought a G-Wagon, which if we get enough super chats, maybe one day. But
I am proud of myself now that you say it. Oh, no.
She earned it. She's a business owner.
Dogs, just wait.
All right, let's see the G-Wagon, and then I'll go back to my live in a second. Oh, that's beautiful.
There she is.
What does that cost? Let me do it. Let me do this.
That's my baby.
2024
So
G-Wagon cost.
I
Oh my gosh.
when I had I still have my Jeep.
Starting at
actually.
$150,000.
That would be great.
150 167.
So my
Yo,
Jeep was
that's
a white
what I'm
Jeep, and I
talking
called
about.
it Betty White. And then my new G-Wagon is white, and I call her Dorothy. But she's Blanche in the streets and Dorothy in the sheets, okay?
wow.
Oh, thank you, Ron.
All right, we're going to let her go. But we got the shout out from Caitlin Bristow. Endorsed. Yeah, my wife wants a G-Wagon. I don't know if it's in the books. We'll have to get the kid.
G-Wagon's name is Dorothy in the streets.
All right.
No, Blanche in the streets
All right,
and Dorothy
so
in the sheets.
anyhow, I can't pause it, but good on her. I'm going to be on her podcast. It'll be going up soon. Let's see. We have some new people. I'm trying to see if anyone's coming in here. Lots of new followers. But anyhow, yeah, good stuff. Let's go back here and just wrap this up. Laura then said, sorry to clarify, Nick was laughing about this case earlier on and playing it down on it being a true crime case. We'd love to see his reaction now that the judge has ruled on the case. Yeah. And well, I'm sure he's going to say like, well, I knew justice would be served. You know what I mean? Even though he has no credit at all. Stephanie said, Dave dribbled before he dunked on Dingus and Dodo Bird. That's right. We dribbled, we shot, we dunked. $10 from AA. Thank you so much for that. And then Julie also with 20 says, what a fantastic day. Thanks for everything, Dave and friends. It's been quite a ride. So happy for Clayton, Greg, and Mike. Looking forward to the continued pursuits of justice. Thank you so much. Paul says she has no jurisdiction over protective orders. Yeah. Vilmari, $2. Victims and spouses should send a letter to the DA. I'm sure they will. And I'm sure we'll find a way to put a petition together to make sure that your voices are heard as members of society. Even if you're not in that voting class, you are a taxpayer and you want to see justice being served. Jen, $20. I'm so happy for all the men who have been negatively impacted by this woman. I hope to God she has learned a lesson here. Cat Lady Ballerina, $2 breadstick money. Thank you for those breadsticks. We appreciate them. Chris Jenner, good pal Chris, sleazy super chat. There it is. Sending in her sleazy super chat. We appreciate it. I'm just a turtle. $5. Thank you for all the work you've done to put into this case. Get some breadsticks. I am off the carbs, but I will be getting some beef jerky. Dan with $25 says, eat it, Gingras. That's right. Enjoy your Italy food. Happy Annie, $5 Canadian. She's being referred to the DA for perjury and tampering with evidence, both felonies. Yikes. Sleazy super chat. More $5 sleazy super chats. Wow. She does not have to pay by July 8th. Woodennick has to give the court his amount and reason for the amount to be paid by July 8th. Got it. Laura Classman, suck it, Gingras, $5. Jojo, $10. I only give sleazy super chats. Oh, who knew we had such a sleazy audience? Juliana, $20. Dave, thank you so much for your perseverance with this case. You totally cracked the case from September until now. You deserve all the kudos for exposing the truth of the lies. Thank you so much for that. Our final, Lady Tammy, $5. Dave, hook Steve up with IT Goatee. Yeah, absolutely. We'll have to get IT Goatee on the job. C. Masi sues, $5. Can her attorney be board reviewed now with this ruling? I mean, honestly, I have no idea. I think he's been disgraceful. That's my opinion. I've let the Arizona board know of the sort of threats that were made. Whether he calls them threats or not, it's really not his call. You can't be a menacing figure in an alley, and when someone says you're threatening, you can't say, oh, I'm not threatening. Bro, you're wearing a trench coat and you're looking threatening. Amanda said, Us Weekly reported on the ruling. All right, well, let's go into it. Clayton, Eckerd, Us Weekly. Let's see what Us Weekly has to say. You know what? We have 2,300 people in the chat. Let's do this. I'm going to share this Us Weekly news after I take a break, and I'm going to do it on Patreon. If you want to join the Patreon, I have to feed them right now. Patreon.com/Dave Neal. We gave you guys all, and you responded with great audience participation, but we did a 2.5-hour live stream. So what I'm going to do right now, I'm going to hit end stream, and I'm going to immediately go live on Patreon. And then I'm going to go make some eggs, but the Patreon chat will be open. So I'm going to let you guys hang out if you so choose. I'll play some of my favorite songs like this one, Buckle Up.
Never gonna stop. They call me Dave Neal, power journalist.
And we'll be back on Patreon.
News, making the hits.
So if you want to join Patreon, by all means, if it's too sleazy for you, I understand that as well. I'm also going to take the baby out of the pouch so it doesn't get too hot.
I earned my keep, covering the world while you're fast asleep.
So, to the public audience, thank you guys all so much.
My passion flashes, I'm breaking barriers, shattering the norm. My words are
all right, I'm going live on Patreon right now. I'll see you on Patreon. Bye, everybody. Thanks for all the support. Thanks for the super chats. See you later.